Primary format mallet.
Yes.
I mean, out of court list mallet in the mention matter. The auction will be held on 5th July mallet. My resident plot will be auctioned by the bank.
There is a vacation court on 4th.
Mallet.
So you file your memo, and I think on 3rd the memos will be allowed. So give your memo on 3rd before the DR, not here. All the matters.
Vacation list item number 1.
Can be the right challenging on the problem diversion.
Yes.
Applying the right challenging judgment of diversion. Degree of diversion. On the ground of cruelty and deaths.
No. You are not the, you are the opposite party.
Yes, ma'am.
So your husband filed the divorce. That has been allowed. Decree of divorce passed. So what is your prayer?
For the appeal, changing the amount permanent alimony by setting aside the
So you are only praying for enhancing the amount of permanent alimony, right?
Yes.
So what permanent alimony amount has been awarded in your favor?
5 lakhs.
What your husband is doing?
The government employment.
Government employee means?
Serving as peon in government school. Yes. 40,000.
What is your age? 31.
31.
When the marriage took place?
10/10/2011.
10/10/2011.
Yes.
Have you got any issues?
No.
No. So any discussion on this? Why this quantity of that amount was fixed 5 lakhs and why not more? Any discussion in the judgment regarding the fixation of the permanent alimony at the rate of at that 5 lakhs? Or it is just fixed after?
Just fixed, not this.
Are you sure? There's no discussion as to assigning reason as to why the court will awarded 5 lakh towards permanent alimony.
Yeah.
No.
This MATA has been filed under Section 28 of the Hindu Marriage Act by the appellant Shaktimoi Tripathi alias Panda against the judgment and order dated 24/4/2024 passed by the Lennon Senior Civil Judge Atgod in MAT case number 37 of 2017 in allowing the petition under Section 13(1) of the Hindu Marriage Act filed by the opposite party husband Biplobi Sangram Keshari Panda and where is that operative part of the order where the
47. 47.
which page is that operative part? and dissolving the marriage solemnized between the petitioner and the opposite party by decree of divorce, and further ordering the opposite party to pay rupees 5 lakhs towards permanent alimony. There are two, as it appears, there are two. One is uh, this copy of the judgment is the same case.
No, that is 39.
Huh?
Restitution of conjugal right that has been withdrawn.
Okay.
By the
No, you have filed two judgments.
No.
One is MAT case number 37 of
37.
2017.
Yes.
Then another, thereafter also another case, MAT case number.
That has not been challenged. That has been withdrawn by the appellant. 39 of 2017.
Right. The Land Council for the appellant submits that the prayer in this MATA is confined for enhancement of the amount of permanent alimony. It is further stated that while fixing the permanent alimony, the learned senior civil judge Atgard has not discussed as to how the to calculate the permanent alimony in terms of the settled position of law. Law is well settled that economic status of the parties, their age, potentials, their respective needs, the capacity of the husband to pay or to be sent. The amount of permanent alimony fixed for the wife should be such that she can live in reasonable comfort, and simultaneously it should not be excessive and affect the living condition of the husband. And also the age of the wife are to be taken into consideration. The Learned Council for the appellant submits that the discussion which has been made in the impugned judgment are not in accordance with the settled position of law. Or admit, call for the trial court report, issue notice to the respondent, requisites by speed post with proof of delivery shall be filed. Within 1 week you file this, within 1 week.
Item 2.
My lord, the wife is the appellant against the judgment passed in a proceeding under section 9 of Hindu Marriage Act filed by the husband and directing the petitioner to accompany the husband within a period of 3 months. Your lords will get it is a composite order. Two petitions were filed, one by the wife for divorce and another by the husband for restitution of conjugal right. In one judgment, both the matters have been disposed of, while rejecting the application of the wife for divorce, the application of the husband has
What
been
is your ground for divorce?
by cruelty. That appeal also has already admitted. Another appeal which is
It is connected to another appeal.
Another. That is 191.
Just a minute.
On
MATA 191 of 2024.
Yes.
Who is the appellant in this matter?
The present petitioner, the present appellant.
That is filed challenging the
That challenging the order so far as rejecting the application for divorce, the prayer for divorce is concerned.
divorce.
That is by the wife.
Here you are challenging the order passed in the favor of the husband,
Allowing
directing you to join the company
Yes.
of the.
That has been admitted by order dated 23rd of
Okay.
May.
This appeal, this matter has been filed under Section 19 of the Family Courts Act by the appellant Ankita Mohanto, challenging the judgment and order dated 19/4/2024 passed by the learned judge, Family Court Baripada, in civil proceeding number 189 of 2021, which was filed by the respondent husband, under Section 9 of the Hindu Marriage Act, and directing the appellant for restitution of conjugal right, and directing the appellant to join the company of the respondent husband. The learned counsel for the appellant submits that on the ground of cruelty, the appellant filed CP case number 210 of 2022 under Section 27 of the Special Marriage Act 1954, and both CP case number 189 of 2021 under Section 9 of the Hindu Marriage Act, and the petition filed by the appellant, that is CP case number 210 of 2022, were heard analogously and disposed of by the common judgment and order dated 19/4/2024. While the petition filed by the appellant for divorce was dismissed, the respondent husband's petition for restitution of conjugal right was allowed. It is further stated by the learned counsel for the appellant that challenging the dismissal of the divorce petition, the appellant has already preferred MATA number 191 of 2024 before this court, which has already been admitted.
by order dated 20th.
Hard admit, call for the trial court record, issue notice to the respondent, speed post requisites for issuance of notice, proof of delivery shall be filed within 1 week.
Yes.
Matter be listed henceforth with MATA number 191 of 2024.
I filed a IA for stay operation of that. Your lordship may issue notice because no execution has been filed. But he is creating problem. She is staying alone with her ailing father and mother. Now he is going
No,
with
why you are apprehending anything? What?
no, he is in fact he is doing so. That is the
No. What is your IA?
number 247 for stay operation of that.
Which
So
order?
for that purpose, so she has to file.
It's not that he has to file the execution.
Yes.
All right. Next.
Item 3.
Another IA is for dismiss certified copy of the.
Acha, this is filed in that.
Yes.
Acha,
That
IA number 8 of IA number 46 of 2020. There is an application filed for dispensing with this certified copy of the impugned judgment. the learned counsel for the appellant submits that against the common judgment, the appellant has preferred passed by sworn, so judge से जो civil ये लिखिए filed MAT number 191 of 2024 and certified copy of the judgment has been filed in the said case. And since both the matters are to be heard together, the filing of the certified copy of the impugned order be dispensed with. Prayer is allowed, is disposed of. Yes.
Miller, please. And I am from VC Miller.
Yes.
Miller, due to some inconvenience, I could not able to go before my lord's court, Miller.
Yes.
And the case is that, Miller, I have given the representation since to 25/4/2024 to the collector, Miller, of Jajpur, stating therein to deploy the paramilitary force or CRPF in the sensitive places where there is every chance of a ringing of the
Another matter, which is your matter?
Item 7. Here, in my matter, the petitioner is the candidate.
Huh?
The petitioner is the independent candidate.
And the allegation that my learned friend's client has made, my lord. There is nothing, my lord. If there is any untoward incident.
Yes,
So I was even mentioned. I told you. You see, Mr. Both of you, this in 4 phases,
my lord.
the General Assembly election as well as the Lok Sabha parliamentary election was to be held in our state, right? 3 phases are already over.
Yes, ma'am.
And the 4th phase election is going to be held on 1st of June. Now, whatever we have collected or we know from the print and electronic media data, except stray incident here and there is nothing. The election are being held very smoothly and peacefully. So why your apprehension that, and you are right that if any booth is having some problem and it is expected that there would be law and order situation, then usually steps are being taken. Now, why this application has been filed?
In my application,
What is your prayer in
there is no interim prayer. My regardment direction may kind of given to the collector to watch the situation, which is the sensitive goods. The numbers I have given, my lord, in my representation
number
by annexure 3.
number 7.
7.
Item number 7. what?
7th of June.
7th of June.
Case matter 24. District administration.
No, come to your prayer. It is item number 7. Your prayer is that to provide adequate central armed police force and CCTV surveillance in 3 booths you have stated. 2 booths. Booth number 97, Sahoo Primary School, 74,
Yes.
Ramchandi Nodal UP School under 51 Dharmasala Assembly constituency. Now, the security personnel, then central armed police forces, then civil police personnel, they have been deployed and they are managing very well and this sort of
I'm not
petition.
voting. My humble submission is page 24.
Yes.
District administration, they have categorized 2 type of booth, my lord. One, Dharmasala Assembly Constituency 51, critical. Under critical, 4 booths they have identified. Under critical.
Is identified means they must have been taken steps.
Yes,
that.
they have taken step. Abnormal, they have 27. In this list, the 2 booths are not there. But client have plans for running phase 26.
Yes.
This is the in last Panchayat election, State Election Commissioner requested the collector.
What you are showing the letter dated 7 to 2017?
Yes, 7 years back.
No, this is not.
My lord, this is continuing because this is the
We are disposing of.
my lord, my representation is at annexure. Annexure, my lord,
PC number
5.
or WPC number 13478 of 2023. This writ petition has been filed by petitioner Sujit Kumar Malik.
No, he.
Number test Sujit. Come 3.
Sujit Kumar Malik.
Yes, Vinod.
All right. With a prayer for a direction to the opposite party
To
number
deploy the
collector judge to deput paramilitary force oblique CRPF in sensitive booth which have been mentioned in the representation of the petitioner by annexure 3 under Binjar constituency. It have a common order for you. In WP CRL number
WPC, my lord.
WPC number 1575 of 2024. The petitioner S.K.Sahoo as
independent candidate.
Stated to be an independent candidate as prayed for a direction to the opposite parties to provide adequate central armed police force and CCTV surveillance at booth number 97 Saroi Primary School and 74 Ramachandi Nodal UP School under 51 Dharmasala Assembly constituency for a free and fair election. Since the relief sought for in both this petition are almost identical, both are heard analogously and disposed of by this common order. General election to Legislative Assembly of Odisha 2024 was supposed to be held in 4 phases. And third phase is already over. Fourth phase of the election is to be held in 42 Assembly constituency along with 6 Lok Sabha constituency on 1/6/2024 in 12 police districts. As per the print and electronic media reports, security personnel including Central Armed Police Forces CAPF and Odisha Armed Police Civil Police personnel have been deployed, and under massive security arrangements, the election has been conducted smoothly and peaceful manner. Though some of the polling booths of some assembly as well as Lok Sabha constituency have been identified as sensitive booth, but it is reported that adequate precautions, including security arrangement, is being done for peaceful election in those booths. Webcasting arrangement has also been done. Micro observers are being deployed in the identified booths to ensure free, fair, and transparent election. The purity of election is fundamental to democracy. The jurisdiction of the High Court under Article 226 of the Constitution of India can be invoked where the State Election Commission fails to discharge its constitutional obligation to hold free and fair election. No material has been brought on record that the State Election Commission has failed to discharge its constitutional obligation in that respect. Therefore, we are not inclined to pass any orders in this writ petition. Accordingly, both the writ petitions are disposed of.
The collector may direct her to only one prayer, my lord, with this, my lord. The collector Jaspur may
Item number 4.
May I please, your lordship? My lord, the petitioner is the licensee in respect of a country liquor shop.
Yes.
The Khandapoda country liquor shop was settled in his favor in the excise year 23-24, my lord. My lord, it is allegation by the district excise office that some ID liquors, 61 ID liters of ID was found possession of the authorized salesman. Accordingly, my lordship, kindly see the Annex 3, page 17. Immediately, as per the direction of the Lord Collector of Nayagarh, the recourse has been taken by the Superintendent of Excise to close this shop. Thereafter, a proposal was submitted before the Commissioner by the Annexure 4, and subsequently by the Annexure 5, page 19, the order has been ratified by the Commissioner and the shop is indefinitely closed. Lordship, I would like to draw Lordship's attention on this section 26. It is a mandatory section 26 of the Odisha Excise Act 2008. May I read, my lord?
Just a minute.
The district magistrate.
Wait. Have patience. Yes.
Section 26, my lord.
Yeah.
26(1). The district magistrate or subdivisional magistrate may, by notice in writing, this is important, to the licensee require that any shop in which any intoxicant is sold shall be closed at such a time or for such period as he may think necessary for the preservation of public peace. Next, my lord, provided that if the closure is required for continuous period more than 3 days, the approval of the excise commissioner shall be taken. So, my lord, here, up to 3 days, the collector has the power to close any shop. Therefore, beyond 3 days, so approval of the excise commissioner is very much required.
Yes.
Lordship may see the Annex 3, the impugned order.
Yeah.
At page 17.
Yeah.
In exercise of power conferred by section 26 of the Odisha Excise Act, the collector and district magistrate Nayagarh has been pleased to order the closure of Khandapada CL with immediate effect in view of the seizure of 61 liters of ID liquor by the SI of Excise District Mobile Squad Nayagarh in Khandapada CLs of premises from the conscious and exclusive possession of authorized salesmen of the said shop. Here, my lord, the provision clearly says is a mandatory mandate before closure of any excise shop in writing to file the response is very much required. In writing in advance, that is prior notice to the licensee required. Lordship, the word is by notice in writing to the licensee. So the district magistrate or the subdivisional magistrate may, by notice in writing to the licensee, require that any shop in which the intoxicant is sold shall be closed at such time for us. This is a mandatory, my lord. Thereafter, beyond 3 days, the approval of the commissioner is very much required. What they have done, my lord, all of a sudden they have closed my shop without giving me any opportunity. On what basis that 61 liters was found in my premises, and subsequently it has been ratified by the excise commissioner by the Annex 5. To that effect, my lord, I have an authority where it has been decided that 26 is a mandatory. Previously, lordship knows there was a Bihar Orissa Excise Act 1915.
No, this Annexure 5 indicates that Annexure 3 was placed before the excise commissioner.
Commissioner, by Annexure 4.
Right.
Recommendation. Then Annexure 5, it has been ratified by the commissioner.
Yes.
Beyond 3 days means indefinite period they have closed now. Up to 3 days, collector has the power. Beyond 3 days, approval
Lordship,
from the
No, you are reading that section not in a properly
my lord.
manner. Provided that if the closure is required for a continuous period of more than
More
3
than 3
days,
days,
the approval of excise commissioner
is
shall be
necessary.
taken.
That annex of 5,
Here that order was passed, no doubt. After that, this proviso does not say that excise commissioner should approve it within that 3 days.
my lord, beyond 3 days, up to 3 days, collector can close any shop for reasons, my lord.
It has been done by
Done.
the collector,
Then
but
beyond 3 days,
excise commissioner passed the order approving within 3 days.
not
That is
within
not
the
there.
beyond 3 days,
Right.
for indefinite
So
period,
when the requirement was for more than 3
3
days,
days,
so it has been placed before excise
my
commissioner,
lord,
and excise commissioner has
ratified
taken a
that,
decision on 19/3/2024,
my
right?
lord.
So
all
what
these
you are
acts,
submitting, that if the order of approval by the excise commissioner is not passed within 3 days,
No,
then
no,
that is
not 3 days, my lord.
That-
My intention that up to 3 days, collector has power.
yeah,
Beyond that the collector doesn't power, lacks jurisdiction.
yes,
For indefinite closure, he has to submit a proposal before the commissioner under the proviso for indefinite, more than beyond 3 days. That language it is there. More than 3
that
days.
proposal has been
that
given in
proposal has
Annexure
been
4.
given in
Given, my lord.
Annexure 4.
Annex of 4 proposal given. It has been ratified by the London Commissioner,
Yeah,
and the shop is closed for indefinite period,
yeah,
more than 3 days.
yeah.
My intention that before putting this off in closure, my lord, they could have given me notice, prior notice. Nothing has been done, my lord. That is mandatory.
It is pursuant to a raid, your lordship,
Yes,
and 61 letters of spurious liquor was found
Yes,
in their possession, your lordship.
Almost
You
same
mean to say that before passing the order under Annexure 5,
5, 3 and 5 both.
no, 3 is not necessary. 5, because it is of for an indefinite period, though your hearing was necessary for that purpose.
First 3 days is also necessary. Lordship, my language. The
No, your
district
lordship,
magistrate.
the
It is to just take an immediate action,
Yes, your
because
lordship.
that 61 liters of ID liquor was seized. That is why immediate action was necessary. Because at that stage, if the notice would have been given and you will submit your reply and you will just carry on your business, then that would
That is
the purpose of the act would have.
because it is not seized from the licensee. It is seized from the premises, from the authorized salesman.
Yes, you are the owner of that
I'm
premise.
the licensee.
You are the licensee.
But it has been
So
seized.
it's all right. You are the licensee, so it is your duty. And how do you sell it? When the
So that is the mandatory provision, my lord.
Your
Lordship, may see.
lordship, it has been closed indefinitely pending in lieu of investigation and
Yes.
such closure.
Lordship,
Your
may see
lordship,
the
pending investigation.
security
So
order.
he will be served with a show cause notice after investigation is over, your lordship.
have you received any notice from the authority?
No, my lord. Nothing. That's
till
why
date you-
I have
Till
approached
date
the
you have not.
No, my lord. Lordship, may see
Your
the
lordship, this election,
already, my lord.
election and all was there, your
Now
lordship. They
it
pending.
is to be.
Your lordship may fix a timeline
Lordship, may
for
see the
completing of the investigation
No,
and issuing of the
the
show
thing is
cause.
that he says that till date he has not received any show cause notice.
Yes, your
I have
lordship.
not supplied with the chemical examination report.
On
Nothing else.
19/3, your lordship, pending investigation, it has been directed that his shops remain closed for
No,
indefinite period.
Please take
And the
instruction.
elections were there, your lordship.
No, we are not passing any interim order just now.
Lordship,
We are
for a
saying
moment,
that
see the authority I have given.
have you issued any show cause notice?
I have
Because
to take
law.
instructions to that
Not
effect.
Lordship, for a moment, the authority I have, because previously it was Bihar
all
Odisha Excise Act. Now it has come back to Odisha Excise Act, my lord. The same provisions, rule section 26. Lordship, see the para 6 and 7 of the operating portion of the judgment, my lord. That has been decided that is a mandatory. Para 6 and 7 of the judgment. Last portion of the order, my lord.
This is immaterial, lordship. This is a judgment which relates to whom license for sale of intoxicants should not be granted.
All right, you take instruction. Lego.
Yes,
And
your lord.
also basing upon this judgment, my lord, this and the coordinate bench, my lord, this is the order, my lord. I'm passing, my lord.
This writ petition has been filed by petitioner Sumitra Sahu with a prayer to quash the impugned order under Annexure 3 passed by the Lenin Collector Nayagar, so also Annexure 5 passed by Excise Commissioner Odisha.
3 and 5, my.
Right, 3 was been passed by Collector Nayagar
Five.
and 5 has been passed by Excise Commissioner
My lord.
Odisha. Under Section 26(1) and 47 of the Odisha Excise Act and Rule 35 of the Odisha Excise Rules 2017, with a further direction to the opposite party number 3, Collector Nayagar, to renew the license of the petitioner for the excise year 24-25 and allow the petitioner to open her Handapada CL sub. The London Council for the petitioner drew the attention of this court to Annexure 3, wherein the Superintendent of Excise Niagara has mentioned that in exercise of the power conferred under Section 26 of the Orissa Excise Act 2008, Collector and District Magistrate Niagara, his opposite party number
3, my lord.
3, has been pleased to order the closure of Khandapada CL sub with immediate effect in view of seizure of 61 liters of ID liquor by the SI of Excise District Mobile Squad Nayagarh in Khandapada CL sub premises from the conscious and exclusive possession of the authorized salesman of the said shop. The London Council submits that for the approval of the closure of Khandapada CL shop, the Superintendent of Excise Niagara sent intimation uh, requested Excise Commissioner Odisha Cuttack by Annexure 4, and accordingly the Joint Commissioner Excise Commissioner Odisha passed the order dated 19/3/2024 under Annexure 5, directing that the shop should have been locked and sealed in lieu of investigation, and for such closure no permission of any authority is required. And Superintendent of Excise Niagara was instructed to initiate cancellation proceeding by observing all formalities and procedure as per Excise Act and rules. Rule 26, Section 26 of the Odisha Excise Act 2008 26(1 कर दियो, reads as follows. 26(1 टा quote करिए ता proviso टा quote करिए. The London Council for the petitioner drew the attention of this court to a decision of this court in case of Nirupama Barik and versus State of Odisha, judgment and order passed by the division bench of this court 7/7/2015 in WPC number 82 of 2015, wherein it is held as follows. Quote paragraph number 6 and 7. It is further stated by the London Council for the petitioner that no so cause notice has been received by the petitioner from the authority, and the impugned order passed under Annexure 3 and 5 are illegal and liable to be set aside. issue notice on the question of admission indicating that the matter be disposed of at the stage of admission. The Land Council for the state accept notice on behalf of all the opposite parties. Let 4 copies of the writ petition be served on the Land Council for the state. Put up this matter in the week commencing from 24th of June 2024. IA number so and so. Issue notice, accept one set of process fee.
Prayer for interim.
Ah,
Interim ballot.
no.
Because
Yes. Now election is there.
election, sorry, separate area. Otherwise, they'll go for ballot. Otherwise, they'll go for resettlement ballot. Otherwise, they will go for the resettlement. That's why I am any no coercive action ballot.
Land Council for the state shall specifically take instruction as to whether any so-called notice has been issued. In the
section
case
26.
Also about the status of investigation as reflected in the order under Annexure 5. Yes.
Number 5.
But here in this case, after hearing this matter at length, my lord was pleased to observe the submission made by me and also directed state government to obtain instructions because the SOCOs as well as the demand both were issued jointly and severally, my lord. Because in Cuttack district, there are so many defaulter licenses, they could not leave the MGQ for the excise year 23-24. Accordingly, then this demand notice has been raised and they have been asked to deposit the amount as per the excise duty, my lord. Now, your lordship last day also held that the jointly they cannot issue the SOCO's notice as well as the demand. On that score, my lordship had directed to my lord and LGA to obtain instructions.
What is your instruction?
Your lordship, on the previous occasion, please stop from approaching this court once again, your lordship. The coordinate bench, your lordship, had passed an order dated. We are sorry.
I have also.
16/3/2020 on 3/4/2024, your lordship. Wherein, your lordship, the earlier excise policies from the year 21-22, they all allowed the MGU quota shortfall to be carried forward to the next year, looking into the effects of COVID-19 pandemic, your lordship. But the excise policy of 24-25 had no statement regarding carry forward of MGQ quota shortfall, your lordship. So at that point of time, it was said that any government statutory dues which have not been paid, renewal fees that have not been paid, and any penalty that has been levied and not been paid, those shops may go for fresh auction, your lordship.
Right.
On that order, your lordship, the petitioners had approached this honorable court, and a coordinate bench has said that there is no irregularity on the face of the 16/3/24 letter of the authorities, and they said that the excise commissioner, the order passed by the excise commissioner has no palpable irregularity.
No, we are just,
Yes,
please
no.
come to that, what we are pointing out to you.
Yes.
You
Yes,
come
Lord.
to Annexure 3. This is the SOCO's notice
Yes, your lordship.
issued by you, right?
Yes, your lordship.
So you give this, issued this notice and he filed the SOCO's as per Annexure 4.
Yes, your lordship.
So there are number of defaulters in
Yes.
Yes,
Cuttack
your lordship.
also.
Individually, they have not been
Right,
answered.
that is the reason,
Yes,
because
yes.
the representation or the SOCO's which has been filed, they have taken different stands.
My lord.
Yes, your lordship.
So if they have taken different stands in their SOCO's, each individual case has to be disposed of taking into account their stand, not in the manner as you have disposed of Annexure 5. Annexure 5 ରେ ଆପଣ କଣ ଲେଖିଲେ ଦେଖନ୍ତୁ କେମିତି ଲାଙ୍ଗୁଏଜ ହଉଛି, ଉପରେ ଲେଖିଦେଲେ ଲାଇସେନ୍ସିଂ ଙ୍କ ନାଁ, ତାପରେ ଲେଖିଲେ ଆପଣଙ୍କ ଫାର୍ଷ୍ଟ ପାରାଗ୍ରାଫ ହେଲା ଯେ in the meantime some of you have submitted your explanation, some have not submitted till date. On perusal of explanation, it is ascertained that the grounds of explanation as cited by you in your reply, ମାନେ ସମସ୍ତଙ୍କ ପାଇଁ,
Yes.
Not
are
satisfied.
not satisfactory and due to following reason. ଦିଟା ground ଆପଣ ଦେଇଦେଲେ ତାପରେ then you pass the order.
Yes, yes, your
So
lordship. The
he-
background is that pursuant to that order of the Honorable High Court in that judgment, Your Lordship, they had a scheme was formulated by this by the government, Your
No,
Lordship,
we are not.
in which
I am
they were
not
supposed
sure
to
that
pay
way.
the penalties in
What is
50%,
the
30%,
why
and
you
20%.
issued show cause?
Yes,
Why
Your
you
Lordship.
issued show cause notice? What is the purpose behind issuing show cause notice? That he is to file a reply, and you are to consider the reply,
Yes, Your
and
Lordship.
the consideration should be in a fair manner. But if you invite the show cause and different persons file the show cause taking different stands, how can you abruptly, just in 2 lines, your explanation is not satisfactory, just reject all the application in a common order? So that
If I may pray, Your Lordship may remand the matter to the authorities
So-
and a fresh.
no, that is obviously that
In
that is the
similar-
reason why, because it has notice has not been issued. We pointed out to you that
Yes.
this is the, on the face of it appears
Yes.
that
Yes,
and
collectively, Your Lordship, they
you
have.
cannot say are you saying that all the defaulters have taken the same stand? It cannot be. It is different stands have
Or
been taken.
the
You are just
defaulters
pick-
are on the same footing, Your Lordship, to the extent that they were all had prayed for
but
the
they are-
carryover of their
but
MGQ shortfalls.
their replies may be different.
Yes,
This petitioner, you see, in Annexure 4, his so-called reply,
yes.
it carries, let us say, 3 pages.
My lord.
He has mentioned so many things. He has stated no legal sanctity and etc. etc. His personal things have also been mentioned. So it would have been better if you have dealt it individually, not in a routine manner, just one line that your all your 20-25 ଜଣଙ୍କ ନାଁ ଉପରେ ଲେଖିଦେଲେ ଆମେ ଆପଣଙ୍କଠୁ ଆପଣ ମାନେ ଯୋଉ ଫାଇଲ କଲେ ତା ଦେହରୁ ଏଇ 2ଟା ପଏଣ୍ଟ କମନ ଜଣା ପଡୁଛି, ଆପଣଙ୍କର ଏକ୍ସପ୍ଲାନେସନ ସାଟିସ୍ଫାକ୍ଟେଡ नो रिजेक्ट. So that is the way we that is not the way in which purpose of inviting show cause is frustrated by passing this sort of order.
I pray it may be remanded, Your Lordship, and their replies be.
Remanded to the government, because similarly, only just for
No,
your lordship.
it is to be considered by the
By the-
authority, appraised, and
Lordship,
that's
one,
all.
one point I had raised, that the superintendent of excise lacks jurisdictions.
That
I have
stand
raised-
you have taken on your
My lord,
representation.
I have taken my.
So that is to be, see कौन कि आपण जदी इंडिविजुअली आपण
ଆଜ୍ଞା।
डिसाइड करथांदे ताले होय तो से स्टैंड को आपण डील करथांदे, से तो डील कलेनी ना.
What they have done, exact what amount of LPL I have not lifted, they have not mentioned.
It's
Nothing
all right.
else. What is the excise duty? They have not mentioned.
The writ petitioner Guru Prasad Sethi has filed this writ petition under Article 226 and 227 of the Constitution of India, with a prayer to quash the demand notice number 4423 dated 13/2/2024, issued by the opposite party number 4 Superintendent of Excise Cuttack under Annexure 4. It is the contention of the Land and Council for the petitioner that there are several defaulters in
Cuttack district.
Cuttack districts, and relating to their what is the general allegation that
That is non-lifting of MGQ.
then
the period of 23,
relating to
24.
non-lifting of MGQ
of the excise year
duly
23,
for the year 2021-22, 2022-23, and 2023-2024, and for non-renewal of excise shops for the year 2024-25. ये लिखा है Annexure 3 रो subject matter लिखा है. The Land and Council submits that after receiving such a show cause notice under Annexure 3, the petitioner submitted his reply under Annexure 4, wherein he has highlighted that in view of Rule 149 of the Odisha Excise Rules 2017, it is not within the domain of Learned Excise Commissioner, खाली learned टा काट देंगे, Excise Commissioner Odisha, to issue so cause notice.
Well, 3480, that's superintendent, just above, my lord.
And
34.8. It is pertinent
in view of Rule 34(8) of the Odisha Excise Rules 2017, the
superintendent of excise lacks jurisdiction
the superintendent of excise lacks jurisdiction
to issue demand notice.
to issue demand notice. ହେଲା ଏଇ ଲେଖା ହେଇଛି ଆପଣ page 29 ରେ ଅଛି, first subparaଟା ଦେଖିନି quote କରିବେ. The Learned Council further submits that the authority without examining the stand taken, अच्छा सेटा inter alia करिवे, से जो so cause रे inter alia the stand taken by the petitioner.
My lord, sorry, just below that my so-called reply, just I have taken stand. The policy says license would be renewed up to 31st
It's all
July
right. We
2024.
have stated that inter alia means amongst other things you have taken also this stand. The Learned Council for the petitioner submits that without individually and similar representation and number of representations have been filed by the other defaulters, and the authority, while without considering the individual representation in proper perspective, pass Annexure 5, wherein it is mentioned that the grounds of explanation is not satisfactory for the following reasons. The data reason दिया है Annexure 5 report कर दिया. The Learned Council urged that the purpose of issuing the so-called notice has been frustrated by the manner in which the order under Annexure 5 has been passed and demand has been raised. And therefore, Annexure 5 cannot be sustained in the eye of the Learned Council for the state was asked to obtain instruction as for the order dated 28/5/2024. After arguing for some time, Mrs. Patnaik fairly submits, Learned Additional Government Advocate, fairly submits that the opportunity be provided to the authority once again. Authority means superintendent of excise.
Collector, my lord.
Who?
Collector is the authority.
Who is to your
demand notice has to be required issued
you
by
have,
the
you
collector.
have submitted the representation to superintendent of excise.
Ah.
So superintendent excise is to consider the same.
Because he has no jurisdiction, lack jurisdiction. That's why he had issued. That's why we have given.
That he has to decide, no? Superintendent of excise to deal with the reply filed by the petitioner, and while dealing with the same, he has also to take into account the grounds taken regarding his authority to issue such so-called notice. Needless to say that we have not expressed any opinion on the merits of the stand taken after hearing. So we are passing this demand notice in view of the foregoing discussion. The demand notice under Annexure 4 is quashed, and the
Annexure 5.
Annexure 5.
Yes, Annexure 5.
Annexure 5 is quashed, and the superintendent of excise shall take a decision within a period of
individually with
individually within a
giving
period
opportunity of hearing.
Just a minute.
Individually.
Individually. कितने
8 weeks.
2 weeks, 3 weeks,
8 weeks.
8 weeks.
Yes,
All right. Within 8 weeks. Accordingly, the writ petition is disposed of. Yeah.
My lord, till then I may be protected, my lord.
Protected, you know.
Yes, my lord. My lord.
No,
I can say
now the demand notice man, you cannot
I
give
can say
any.
the settlement.
No, that order has been quashed. How can you that order in which the demand was raised, that has been quashed. How you are apprehending anything that by virtue of that order which has been quashed, they will again pass anything?
But
Yes.
next two other items, my lord, same
Same.
Okay,
same
same.
annexures.
All right.
Annexure 5. Obliged, my lord.
Item 6.
May I please, Your Lordship?
Item 5 bola 6. Yes.
May I please, Your Lordship? My lord, here in this case, the present petitioner is a 19-year-old boy and he is an aspirant of JEE main examination. And my lord, while he is an aspirant of JEE main examination 2024, my lord, and while the present petitioner filling up his applied for the online, during filling of the application, the petitioner, instead of filing the reserve category, that is EWS general category, he mentioned as general category, my lord. And the present petitioner filed this writ application seeking a direction from Honorable Court to change the category from general to general EWS, my lord.
How is it permissible now? You have filed your application. If you, according to if you have given some wrong data in it, so when the process is already over, how at this stage it will be permissible for to you to change the form itself?
My lord,
Form रे आपण जो stand टा नेइचंती, आपणकर entire process is over or not? Selection has been
no, my lord, counseling not yet started.
counseling जो ହେଇନି जे आपणकर जो आपण लेखिचंती पुरा come to your
My
the you see paragraph 4 what you have mentioned, that the petitioner was assigned the roll number so and so, you face the examination,
Right.
answer scripts have been evaluated, and you have been declared that you have secured this particular mark,
Right.
and your rank is also this.
My lord,
So now everything is to be changed.
my lord, when the rank list appeared, that time the petitioner got to know that he is wrongly applied. And
You mentioned that you are a general category. Now you are saying that no, I am not a general category. I will come under that
general EWS.
general economic backward. So
my lord, in that light, I have two decisions. If your lordship permit, I am submitting.
no, question is at that stage there is
My lord.
two things.
My lord.
If the matter would not have gone to the stage of evaluation, matter is different.
My lord.
So now by this process, you are likely to come to the top. Mane top
My-
means
as the
ଆପଣଙ୍କର
section,
rank ଉପରକୁ ପଳେଇଯିବ.
upliftment
So
of the
some persons are likely to be also affected. ତାଙ୍କ ପୋଜିସନ ତଳକୁ ପଳେଇ ଆସିବ ନା ନାହିଁ? ଆପଣ ବର୍ତ୍ତମାନ ମନେ କରନ୍ତୁ 18 let us say 55 ରେ ଅଛନ୍ତି. ଏଇ ଯେ ଆପଣଙ୍କ ଷ୍ଟାଣ୍ଡ ଟାକୁ ଯଦି ଆକ୍ସେପ୍ଟ କରାଯିବ, you may go to number let us say 25 ହେଲା. ତ ଯୋଉମାନେ ରହିଗଲେ in between ସେମାନଙ୍କର rank ବି ଖସିଯିବ. ତ ସେମାନେ affected ହେବେ ନା ନାହିଁ? ତେଣୁ ଆପଣଙ୍କ ଫେଭରରେ ଗୋଟେ ଅର୍ଡର କରିକିନି ସେମାନଙ୍କୁ ନ ଶୁଣିକିନି ଯୋଉଥିରେ ସେମାନେ affected ହେବେ, how far it is proper?
as this is a bona fide mistake, that is not prejudicial.
No, you are only looking at your interest. You are looking at your interest, but you are not looking at what harm will be caused to the now it's a she point something is has many effect also. Somebody may lose one seat in a good college because of this percentage of mark. So mistake has been not, it is not the fault of the authority. You have mentioned that you are a general category student. So they have accordingly they have assessed you and given. Now everything was over. You are coming. No, I am. So that is the problem. If nothing would have been done, matter is different.
After this declaration of the score, the person is got to know that he is as a common rank list holder in the general category. Then after he approached the authority, and in that light,
after publication of the result, he must have realized had he applied under that that category, for that there is a 10% reservation. He would have. That is why.
That is the reason why yes.
If your lordship
There is a reservation for that, 10% reservation.
as your lordship.
General economically weaker section category, 10% reservation.
Padi, what you say, Mr. Padi?
see the annexure 2,
Yeah.
they might have known after this score.
He's agreeing. He's agreeing that.
So in this stage, nothing can, because NTA is conducting examination. The Ministry of Education or NTA is doing so.
What decision you are? नहीं से it ऐसे केस रे कोन ए स्टेज रे किछि
Again. After declaration of the results, she got to know that wrongly there is two decisions. One of Karnataka High Court Division Bench of Karnataka.
10% reservation रे भी जदि आसी, one person has to be eliminated from that list. So he is a necessary and proper party.
Fact is para in Karnataka judgment. The fact is para 213. My
Paragraph?
My lord, paragraph 213 is the fact of the case that the person is my relevant para is not 9, paragraph 9, paragraph 9, 14 to onwards, my lord.
Take instruction.
Yes. Vaccination.
WPC number 13513 of 2024. The petitioner Shashwat Rao has filed this writ petition for a direction to amend oblique change his her application as application which was submitted for JEE main examination of the year 2024 from as generally economic weaker section category instead of general category. The Land Council for the petitioner submitted that while submitting the application form, inadvertently the petitioner mentioned or to be coming under general category. But in view of which is the document which would show that you are, but annexure 3,
EWS certificate.
Which was the certificate issued by Collector Keunjhar would show that the petitioner comes under general economic weaker section category. And therefore, if the change amendment or public change is made in her application, she would get good rank
Admit top college.
in better college and will be admitted in the better college. And counsel for the petitioner cited decisions passed by the division bench of Karnataka High Court date. Date nahi hai. Acha. 10th August 2023 in Dr. Lakshmi P. Gowda versus National Board of Examination in Medical Sciences. And division bench decision of Delhi High Court passed in Ms. Charu Kain versus High Court of Delhi, passed dated decision dated is judgment dated 3/6/2022 in WPC number 9230 of 2022. The decisions are taken on record. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Mr. Padil and Assistant Solicitor General, Additional Solicitor General has entered appearance for Deputy Solicitor General, entered appearance for
1 and 2.
opposite party number 1 and 2.
Copy received.
You have received the copy.
Extra copy they will show.
He has received the copy of the writ petition. Let extra copy of the writ petition be served on him. Put up this matter. We commencing from 24th. 24th of June 2024, because there is some urgency.
Yes. Case. Examine.
Oh, thanks.
Item 8.
I pass on a sleep mail along with me, Mr. Guchat bearing all case I'm mass sleep.
ଏଇଥିରେ ତ
ଏଥିରେ
ଆପଣଙ୍କର ନାଁ ରହିବ ପ୍ଲସ୍ ତାଙ୍କ
ଆଜ୍ଞା ମୁଁ ଦେଇ ସ୍ଲିପ ସାର୍ ଦେଇ ଦେଇଛି ସବୁ.
yes.
In this writ application, petitioner seeks a direction for providing power supply to the industrial unit of the petitioner against the deposit made by the petitioner as well as in terms of the order passed by the grievance redressal forum Dhekaran. What happened in this case, my lord? The petitioner purchased stone crusher on 14/8/2023 from Samola Infrastructure and paid the pending bill of the electricity used by that time. And thereafter, they applied for fresh connection in name of change of the petitioner on 22/11/2023. And the electricity department issued the demand note. Accordingly, the petitioner deposited 1,180 for change of name and fresh connection. And thereafter, another demand notice issued by the electricity department for depositing of 11,45,405 for security, towards security amount, my lord. And as for Annexure 5, I have also deposited that security amount before the electricity department for providing power supply. And they have not, that all process has been completed.
You are having a stone crusher unit, right?
Yes.
So there was default in making payment of the electricity dues. That is why disconnection was there.
Yes.
Now, thereafter
the
you
power was earlier the connection was in the name of the previous one. That was disconnected.
No, you are running that stone crusher unit. Now you applied fresh connection.
Yes.
They said that you are to clear of the arrear dues.
Of
That
the previous one.
Right? Previous owner,
Yes.
ଆପଣ ଯେତେବେଳେ ଆପଣ ये responsibility आपन को shift है ना जो organization आपन करो आपन जिते बड़े carry करचंदी सेई stone crusher unit को तारो against रे जेती की outstanding dues थिला आपन आप काली सकाळे आपन पुनी ताकू यूज करिवे आपन पुनी लक्ष टंकार बिल करि देगिन छाड़ देबे तापरे आपन आउ गुटे काहाकू देई देबे से ताले how they will just go on giving you electricity and they will not get anything because the owners are changing from time to time.
I am ready to pay. Well, your lordship kindly see Annexure 12. That is the order passed by the Grievance Redressal Forum, Tenkara. And in that order, the GRF has decided.
So what is the outstanding dues against you? So you are ready to pay.
The Lorded GRF has directed to reassess the amount at page 41, lordship kindly see. Running page 41.
40?
Direction of the forum. 41. To completely waive off the revisions of the loan from 5 to 2019 to 11 2020 and reassess the bills only for 2 years, that is from 12 2020 to 11 2022 for accounting the escape billing, and the petitioner may be considered to pay the revised amount in monthly installment as per terms of TPC.
So what happened?
They became silent and I am sustaining huge loss each day, my lord.
So you are ready to pay that amount?
Yes.
What
And
is the section?
It's the DOCL valid rate to respond.
What?
Opposite parties.
TPC or DL. Notice is to
Acha.
Notice has to go to them.
And it's the 13 series also they have made 2 representations.
You will accept notice for one only.
Yes.
And this executive engineer Dhenkanal Electrical Division?
That is also TPC in the state.
Okay, so for 2 and 3 notice has to be.
Yes.
All right. WPC number 13594 of 2024. The petitioner Jyotiranjan Mahanti has filed this writ petition seeking for a direction to the statutory authorities to provide immediate power supply to the industry of the petitioner, thereby complying the order dated 13/3/2024 passed in GRF case number 17/2024 by GRF Dhenkana. The Learned Counsel for the petitioner drew our attention to Annexure 12, wherein the order has been passed to completely waive off the revision of bills done from 05/2019 to 11/2020 and to reassess the bills only for 2 years, that is from 12/2020 to 11/2022 for accounting the escape billing. And the petitioner is to pay the revised amount in monthly installments as per norm of TPCODL. The Learned Counsel for the petitioner submits that the petitioner is ready and willing to clear off the outstanding dues as per the order of passed by so and so. Hello? GRF Grievances Redressal Forum, TPCODL, Denkana. And immediate power supply to the stone crusher unit be restored. Issue notice on the question of admission, indicating that the matter shall be disposed of at the stage of admission. Learned Counsel for the state accepts notice for opposite party number 1. Issue notice to the opposite party number 2 and 3 by speed post with proof of delivery requisites will be filed within 1 week. Matter will be listed.
IA is there. When
Honda?
IA have filed for giving temporary.
IRA issue notice once accept one set of process fee, matter to be listed on 24th June 2024. Yes.
24 June में
24 June रे आसीबो आपन को गोटे सप्ताह भितरे स्पीड पोस्ट रिक्विजिट्स दाखल करिया पड़िबो हला फॉर ऑपोजिट पार्टी नंबर 2 and 3. Yes.
May I please, my lords? Because the petitioner is a works contractor, so I participated in a tender, my lords.
Yeah.
My lords, and the opposite party number 4 is the lowest bid, lowest financially qualified bidder, and the opposite party number 5 is the second lowest, my lords. Now here, my lord, my entire endeavor is to prove that opposite party number 4 has defaulted and submitted fraudulent documents apparently from the tender documents he has submitted. Now, my lords, firstly, my lords, I'll show one essential clause, my lords, that before
Technical Evaluation Committee.
My lords, at Annexure 6.
Yes. So that you are challenging.
Yes. Now, my lords, what is the my lords, if sees Annexure 6, my lords?
So the scope of interference in such matter
is
as per the decision of this Honorable Supreme Court and this court is very limited.
Very limited. Yes, my lord. I bow down to that. Now, my lords, I'll show that in that limited sphere, I fall down, my lords. That is my entire endeavor, my lords.
If you say that it is he has supplied, he has given some forged document.
Yes, my lords.
You have, yes. Let us say he has given some forged documents. So, if it is forged document, can we here take evidence or decide that? Then how?
No, my lord. The answer to that.
How can in a read jurisdiction?
What my grievance is, I have approached them. They did not take any decision. Since 2 months.
Where have you approached?
My lords, Annexure. My lords, Annexure 11 is pending. And it is pending since 16/2. After that, they issued the LOA, letter of acceptance. Now here it is another catch.
Yes, Council. Annexure 11 is dated 20th February 2024.
Yes, my lords. And my lords, the next annexure, my lords, next annexure is 12, page number.
That is annexure 12.
Yes, page 2.
Dated 19/3/2024.
So even after I intimated them all the deficiencies, they have gone for the LOA.
You mean to say that you have not received any reply?
No, the LOA or copy also I have not received. I received it in the month of 20th May 2024. I got it from some credible.
Have you specified which are those documents which are according to you the forged ones?
Yes, my lords. Please see, my lords, the page 240.
Now this it might have in the meantime signed the agreement.
No, it has not been done. I have instruction. I will reflected in the petition also. That no agreement.
Status of that work.
I need to take instruction, but first, your lordship, see annexure 6, which he wants to be quashed.
Yes.
There, he himself is also has been technically found suitable. So once he is there in serial 2.
Yes.
He wants this to be quashed, which is in his favor.
No, who has selected in this one?
The technical. This is the technical bid which was open, and it's one of the.
He is that Ajay Infra. He has been placed as number 1,
and he is number 2.
Right? No. What he says that
that I understood that he had given some mail
document.
One document is prior to the grant of LOA.
We say that how can we assess here?
Yes.
That it is a forged document unless we take some evidence and the scope of read jurisdiction.
Yes,
so that is why when he has pointed out to the authority that some at least 2 documents are forged document, then you should have
what steps authorities are taken.
Somebody has been placed in number 1. If that is because of filing of those forged document and it is brought to your notice, you should either see it that whether it is the stand taken is correct or not.
Yes.
So you are not.
Sure, wisdom they might have taken, but let me take instruction in that.
If he stated that he has got no reply, maybe that you might have issued the reply and his.
But your lordship may bear in mind that one email is prior to the 19/3.
All right,
next
you just
to-
take
next to
you
him, I
just take instruction. We are
I'll take
keeping this matter.
Milords, all the objections are prior to 19.
It's all
That
right.
is my summary.
The petitioner, Messrs. Balaji Solar System hyphen Messrs. Unicorn India Private Limited joint venture has filed this writ petition challenging the technical evaluation summary under Annexure 6 and freeze for quashing the same, as the same is illegal, arbitrary, and based on improper consideration of the technical bit. The Land Council for the petitioner drew the attention of this court to Annexure 6, which is the summary of the evaluation technical bits. And it would show that the petitioner has been placed at number 2.
No, Milords, I'm not number 2. Milords, I'm number 5.
Petitioner has been placed at number 5.
Yes.
Number 5, and who is the opposite party who has been placed as number 1?
This is the opposite party number 4.
And the opposite party number 4, Ajay Infra,
Yes, Milords.
has been placed as number 1 in that report under Annexure 6. It is the contention of the Land Council for the petitioner that the opposite party number 4 has submitted some forged documents, and therefore his case should not have been considered at all. And highlighting all these aspects, he sent email to the authority via Annexure 11 series on 20/2/2024. So also a representation on 19/3/2024 under Annexure 12.
No, Milords, Annexure 12 is the LOA issued by them. My annex page 240.
No, what is your representation? Just tell us.
My representation is page 240, that is February 20th, 2024.
Annexure 11 series.
Yes.
And till date, he has not got any response from the opposite party number.
Opposite party number 3, Milords.
Opposite party number 3, Engineering in Chief, Rural Water Supply and Sanitation. Land Council for the state has received the copy of the writ petition and seeks some time to obtain instruction in the matter. Put up this matter on 24 June 2024. The status of the work in question has to be obtained. So also it is to be ascertained whether any agreement has been entered into with opposite party number 4. Yes.
Till that moment, Milords, just one in my application, I've stated that they are proceeding and they have asked for the ECI for a clarification and to sign the agreement.
Next case.
Item 10.
Item 10.
May please, your lords. May please, your lords.
Yeah.
The petitioner is challenging, who is allotted a bridge work, challenging the recession with penalty, 20% of the leftover work. Annexure 2 is the approval order government, that is page 19, your lordships.
No, when your agreement was executed.
Yes, your lords. The agreement was executed 12/9/2018, my lord.
12/9/2018.
Yes, lords. I have to complete the work.
Work within
my lord 18 calendar months, that is 12th March 2020.
12th March 2020.
As on today, I executed, my lord, RA bill was with annex, that is 9 crore, my lord, 65%, my lord.
So after 12/3/2020, any extension was given to you?
Extension was provided.
How many times it has been extended?
Twice extension, your lords. Annexure 10, my lord, I have lords.
Twice you have got extension?
Yes, your lords. Drawing was only provided 8 June 2022, my lord.
So I have during when the last extension was given and to complete the work by?
By, my lords, by March, I have quoted my repetition.
Quoted con, why have you not filed that document
That
relating to extension?
sometimes they have not or they have allowed post the construction.
କଣ ମୌଖିକ ଆପଣ କହିଦେଲେ ଆପଣ ଏତିକି ଭିତରେ କାମ କରିଦେବେ, ସେମିତି କଣ ହୁଏ କି? ଆପଣ କହୁଛନ୍ତି ଆପଣଙ୍କୁ ଦିଥର ଏକ୍ସଟେନସନ ଦିଆହେଲାଣି, ଯୋଉ ଷ୍ଟାଣ୍ଡ ନଉଛନ୍ତି ତା ବିଷୟରେ କଣ କିଛି ଡକୁମେଣ୍ଟ ଅଛି ନା ଏମିତି ଆପଣ ମୌଖିକ କହିଦେଲେ ହଉ ଏତିକି ଦିନ ଭିତରେ ସାରିଲେନି ଏତେ ଦିନ ଭିତରେ ସାରନ୍ତୁ? ଏଟା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ୱାର୍କ ଟା ନା।
Yes, they have the two
where is the document?
Yes, I am first extension. Annexure 5, your lordships, this is the first extension.
And as per the agreement, there must have been a clause that if you do not complete it within this period,
yes, lords,
then what would be the consequence?
Yes, lords.
So if you have not only completed within that fast period, 12/3/2020, because of that COVID extension were granted you twice, and thereafter also you have not completed. So what is the illegality committed by the
yes, lords,
merely because you have completed 65%?
Yes.
So there is a time limit to commit it.
Exactly.
Ultimately, it is to be used for public purpose.
I am also
taking of that work from 2018. 6 years are to be passed.
My humble sample, annexure 10 page 70. The drawing, your lordship. The clause provides any changes in the drawing I have to accept, and the clause provides also shall grant extension of time. Page annexure 10 page 79, your lordship. Kindly see the date, your lordship. The 3-4 times they changes the drawing specification has been changed, your lordship. Page 79, your lordship. Annexure 10, your lordship. This is addressed to the petitioner, Miller. And subject, this is the construction of so-and-so work, your lordship. Regarding drawing well cap, abutment, shaft, return wall, dat wall, and pedestal of abutment. Dear sir, with reference to the above cited subjected, it is enclosed here with the drawing number 232.
That work is now allotted to somebody else?
No, this is recently resigned, 9/5.
So what do you say, Mr.
Which document my friend was showing, it's 2022. And the tender has been rescinded recently, May 2024. So how can I now rely upon this document?
2020. This is I have to complete and March 2020.
Kindly look at what is the prayer.
Page, your lordships, page 14, your lordships.
Yeah.
The order under Annexure 1 communicated to the petitioner by opinion in the opinion 2 in approving the rescission of contract. How can you challenge the approval recommended by the authorities? Because we did not abide by the terms of the agreement.
No.
So it's a now he can go to before the appropriate forum. Or he court cannot decide whether it's correct or not.
That regarding maintainability, I have a authority that if the in respect of work which is arbitrarily terminated without consider maintainable, on a recent judgment of Supreme Court, I have.
No, it's all right, but
your lordship, one more, 2000. This is a complete of March 2020.
No, we just want to see those documents where this you say na extension has been given.
You want Annexure 5, your lordship. Sorry, I could not have.
This must be the first extension.
Yes.
No. You say that twice the extension has been.
Yes, Miller, I'm showing the first.
If we have correctly heard you, then you said that twice extension has been.
Yes, given. Annexure 5, page 68.
Annexure 5 is the last extension.
Thereafter, the provisional granted first extension, your lordship. Provisional
please bring those documents. This is dated 13/3/2020.
Yes, Lord, the extension.
We are in 2024. If extension at all been granted for what period, and when that extension period elapsed, and thereafter if you just sit over the matter, the authority is to see that how that bridge construction is.
Your lordship, definitely. One document, page 88, your lordship. Page 88, the extension last payment, your lordship, kindly see. Page 88, their own bills, my lord. Page 88, my lord. This is the running account bill, your lordship.
ସେ bill ଆପଣଙ୍କର bill payment ରୁ କଣ ଜଣା ପଡିବ କି କେବେ extension ହେଇଥିଲା?
sir 12/2 ରେ 12 February 2009
you produce
I'll produce. What happened, your lordship, can see they the annexure one.
Please produce, and it may be it can be taken up in the Baxon bench if you produce that. If you file the memo, it can be taken up. So
one thing, your lordship has to be I'll produce, but your lordship has the specifically in this 2BI charging penalty. Your lordship, the annexure 1, they are.
Counsel, when you are taking a stand, that stand must be supported by documents.
Yes.
If you are not filing the documents and it is not also available with you now,
Yes.
on basis, what basis you can seek relief? Nothing is there before us. The work is of the year 2018.
Yes, Lord.
You are supposed to complete it by March 2020.
Yes, Lord.
We are now in 2024 June almost.
Yes, Lord.
So how can we say that
Well, the drawing
main
was
extension given, and that too for how many, what period it was granted? You want now further extension of 8 months.
Yeah, Lord. So, what I'm submitting, Lord.
Already filed by
One more submission, last submission.
sorry. This writ petition has been filed by Navdurga Construction Private Limited with a prayer. देखिए लिखे जाते. The Learning Council for the petitioner submitted that the petitioner was assigned the work, that is construction of HL bridge over river Budha Bolanga at so and so annexure 1 ର top ରେ ଲେଖା ହେଇଛି by the agreement number so and so, dated ହଉଛି 12/9/2018, and he was supposed to conclude the same on or before 12/3/2020, and thereafter twice extension has been granted in favor of the petitioner, and the work is 65% completed. But the authority is now bent often to give the work to another person.
Milord not given. It is rescinded with penalty. Milord. Not 100. Milord not allotted. This is annexure 2, Lord. It is rescinded with penalty of 20%.
And the petitioner has been annexure 2 को refer करी imposed a penalty of 20% of the value leftover work, which has to be realized from the petitioner as per clause 2B Roman 1 of P1 agreement. Hello? A stand has been taken that a further prayer has been made to direct the opposite party to allow the petitioner to complete the balance work within 8 months from the date of order for the work. When we made a query to the Land and Council for the petitioner as to where are the orders regarding grant of extension to the petitioner, he seeks some time to file those documents. Put up this matter when moved during vacation, and if not moved in the week commencing from 24th June 2024, the Land and Council for the petitioner shall file the documents of extension granted by the authorities in favor of the petitioner. In the meantime, giving copies thereof to the Land and Council for the state. Yes.
Obliged.
Item 11.
Very pleased, Your Lordship. Here I have challenged the Annexure 7 demand notice for shortfall MGQ, my lord. My case is that under Annexure 2 at page 14, the authority has served a notice stating that there in the next page, page 15, for shortfall MGQ of 8,241.6 LPL up to 29/2/2024. Under Annexure 3, I have lifted the shortfall MGQ of the month of March 2024 along with this 8,000, my lord. And that is the calculation is at page 23, my lord. I have lifted 11,812.04 LPL of the LPL. Now suddenly on the very, my lord, at page 26 and under Annexure 4, on the 1st April 2024, they have served another notice that there is a shortfall of 9,984.76 LPL. Whatever they have stated in the under Annexure 2, along with the March month MGQ, I have lifted, my lord. But again,
But
they have
this order which you are challenging under Annexure 7,
Mallard.
in the first subparagraph, it is mentioned that you have defaulted to lift this much of IMFL during the year 2023. So that is, how do you say that you have already lifted? On what basis?
Mallard, under Annexure 2, kindly have a glance at page 14 of the brief.
And then the rest of the things is as for their excise department later,
Yes.
that what would be the consequence.
Yes, Mallard.
So accordingly you are to.
Well, kindly have a glance to the page 14, Annexure 2.
Where have you taken a stand in your petition that there is no default on your part and you have already lifted that? Where is the stand taken? That whatever has been mentioned in Annexure 7,
Yes,
that you have defaulted to lift this much of IMF during this one, so it is not factually correct. It's an incorrect statement. Rather, you have already lifted the default.
Paragraph 5, my lord. Paragraph 5(6).
Yeah.
When I have taken the stand that if at all that is a shortfall, they could have been intimated me before the 31st.
ଗୋଟେ particular stand ସେମାନେ ନେଲେ ଆପଣଙ୍କର demand notice ରେ ଯେ ଏତିକି ଆପଣଙ୍କର default ରହୁଛି lift କରିବାରେ. Where have you taken the stand that no, that is an erroneous thing? You have already lifted whatever the default MGQ was there. So what is that stand?
My lord, paragraph 6 to 9, my lord. They have said that there is a mistake in their first notice, which they have rectified on the 1st of April 2024. And they have solved the second notice. Immediately, I have given my show cause, my lord. In the show cause, I have stated that.
No,
Annexure 5.
Right. After considering your show cause, this.
No, they have not considered my show cause, my lord. Till date.
Where is your show cause?
Annexure 5, page 27.
When you submitted that show cause?
Within 7 days of as directed.
The date is not given.
Not given, my lord. Along with this affidavit. Affidavit is
no, this is in reply to the notice dated 1/4/2024.
My lord.
Okay. So you mean to say after receiving your show cause,
my lord,
so they have not considered your show cause?
No, my lord. They have not considered. Even as per their direction, I have submitted the affidavit at page 29.
Just a minute. Mrs. Patnaik,
ଆଜ୍ଞା
please come to Annexure 4.
ଆଜ୍ଞା
Annexure 4 is the show cause notice.
ଆଜ୍ଞା
That is page number 26. Hello?
ଆଜ୍ଞା
Then he has filed the reply to the show cause. That is Annexure 5 series.
ଆଜ୍ଞା
You got it from page number 27.
ଆଜ୍ଞା
27 and 28. Now you come to the demand notice,
32
which is challenged under annexed as Annexure 7. ଆପଣ reference ଟା ଦେଖନ୍ତୁ, this office show cause notice number 7612. ୟା ଦେହରେ କୋଉଠି ଆପଣ consider କରିଛନ୍ତି ତାଙ୍କର ଯୋଉ reply ଦେଇଛନ୍ତି ବୋଲି ଦେଖିଲେ? ଆପଣ ଗୋଟେ show cause ଦେଲେ, ସିଏ ତାଙ୍କର reply ଦେଲେ, ତାପରେ order ଟା pass କରିଦେଲେ basing on your show cause notice without considering the reply, then what is the purpose of using?
Your lordship, you see the show cause notice at Annexure 5. How does it anyway qualify? There's absolutely no proof that
please come to your show. Hence you are directed to submit show cause as to why the shop shall not be settled at your own loss and risk, and demand notice be issued for such loss of revenue. Your explanation.
I'm referring to his annexure 5, his show cause notice. It is just a plain paper, which is signature. Where is the authenticity that
Oh,
is
you
there?
mean to say that?
Yes.
Acha,
Why
yes,
did
yes.
the office open?
Annexure 5 series को आपण जो लिखिले, how it was sent and what is the documentary
Salute
proof?
signature ଅଛି my lord.
मनोज कुमार मल्लिक जोटा आपण लिखिचंती मनोज कुमार नाहक हां सुपरिटेंडेंट ऑफ
କିଛି
एक्साइज
endorsement କିଛି
एटा
endorsement ନାହିଁ
कोथरे
କିଛି ନାହିଁ
पठेले आपण केबे डेट
by hand ଦେଇକି ଆସିଲେ ସେ
There is
Hand
also
endorsement
government in the writ application as to what was the mode of communication, when it was communicated.
yes my lord because
Though it has been pleaded that it is supported with an affidavit which is dated 24/4/2024,
thereafter they have asked
duly executed before the executive magistrate.
all these are submitted as per their direction. I have been asked to submit the affidavit and I have submitted the affidavit.
Suppose Mr. Guru, suppose they will take a stand now that we have not received this reply.
My lord, that is annexure 7 they have
ସିଏ
referred.
ତ ସିଏ କହୁଛନ୍ତି ଯେ
They have referred.
They have referred my lord.
କୋଉଠି
Annexure
First
7.
paragraph
1/4 କୁ refer କରିଛୁ ନା
with
ଆପଣଙ୍କ
reference to
1/4/2024 କୁ refer କରାଯାଇଛି
if that the so-called reply submitted by you.
କାଇଁ
First paragraph annexure 7 page 32 my lord.
that the with reference to it is to intimate you that the so cause reply submitted by you in response. Then they have considered it. Why you said that they have not considered?
Not at all satisfactory and tenable accordance with the provision of the excise rule. They have not given me a chance of hearing my lord.
Hearing kodi achi mo. Show us that in such a case personal hearing is necessary.
And
So
my lord,
cause notice दियाला आपण reply देले तो consider करी pass कले order टा सेठी आपण कहउजनी personal hearing देइथांदे shows that where it is mentioned.
my lord, my case is not that. My case is that in the month of March they have given me a so-called notice, demand notice under annexure 2 that this is the shortfall amount quantity. Page 14 my lord.
your lordship may see the showcase जोटा ଦେଇଛନ୍ତି କଣ ଲେଖିଛନ୍ତି there's a miscalculation his showcase is basically reply to the showcase is a miscalculation that the authorities have considered and come to the conclusion my lord that there is a shortfall of
My lord, kindly have a glance the page 15 my lord. Kodala 2 serial number 12 up to 29th February there is a shortfall of 8,241.6.
So it will be taken up after vacation. We are just issuing notice. Issue notice on the question of admission indicating that the matter shall be disposed of at the stage of admission. The Land Council for the state accept notice for all the opposite parties. Put up this matter in the week commencing from 24th June 2024. Interim application same notice issued. Yes, next.
your lordship is putting it to 24
24.
Okay.
If you want more time, you pray for that.
yes my lord I'll do it
Next.
Item 12.
May please along. But here also
Yes.
may please along. But here also the petitioner is a licensee of OPSOP. Lord, he was issued with so-cause notice under Annexure 7, page 31, Lord. But here, Lord, the petitioner has not given reply, but he has submitted an application as per clause, Lord, 4.1.3 of the excise policy at page 26, your Lordship can have glance. There is a Lord clause E, a committee under Lordship, page 26.
Yes.
But page 26, clause E, Lord, 4.1.3, clause E.
Yeah.
A committee under the excise commissioner shall consider MGQ related issues faced by licensee. In case of genuine difficulties, excise commissioner may relax up to 10% MGQ on the recommendation of the committee. But as per this clause, but I have filed application before the commissioner under Annexure 8. To relax up to 10% and balance, I may be permitted to lift the shortfall by end of July.
So what happened on that?
But on the basis of this representation, the commissioner, there is a committee, Lord. The committee decided
two proposals, and that proposal under Annexure 10, Commissioner sent to the government. Lords, you kind of glance page 37, Annexure 10. The subject is, Lordship, proceeding of the committee meeting held on 22, constituted in accordance with the provision of under clause, Lordship, 4.1.3, clause E of excise policy, for consideration of representation filed by the defaulting licensee, EP holder, for relaxation of 10% MGQ. Lordship, kind of glance alternate one, the bottom one. There are two proposals. But as per the Lord 4.1.3, Commission is the authority to decide. The Commission has not decided. He submitted two proposals to the government. Alternative one is, Lord, they'll have to deposit the dues in 3 installments. And Lord, second clause is, which is our prayer for lifting, that was also the recommendation of the committee.
No, in page 38, it is mentioned, Mr. Patro,
yes,
that I concur with the suggestion recommendation of the committee on the representation of relaxation of 10% MGQ.
That was not granted, Lord. Relaxation of 10% was not granted. They commissioner what then? He submitted two proposals to the government. One proposal is not with regard to 10% reduction. They said that whatever the duty is on shortfall MGQ, it is to be deposited in 3 installments.
Thereafter, what happened?
Not thereafter, government under Annexure 12, Lord, page 47, accepted the alternative 1 proposal. But with regard to alternative 2 proposal, he has not assigned any reason in the under Annexure 12, which is our prayer was to lift 10% reduction and balance may be permitted to lift. That alternative proposal 2 was that we may be permitted to lift. That was not accepted, and government accepted first one. On the basis of that, now the demand notice has been
alternative. So the choice is with the government. So what is the harm?
If choice is with the government, the 4.1.3 says the commission is the authority. If the commissioner is the authority, he cannot send to the government for approval. He is to take a decision. If he has sent the decision to the government, then government is to assign reason on alternative 2. With regard to alternative 2, because alternative 2 was our prayer. Our representation was with regard to alternative 2 prayer.
Yes.
But has been commissioner has been sent to the government. So why that has not been accepted alternative 2, that government has not assigned any reason in this letter on 17.5, Annexure 12.
Yes, Mr.
The clause note that my friend is referring to is not mandatory notes. May. So it's a privileged communication between the commissioner and the state government. And this is not, because there is no communication to the petitioner that these are the recommendations and which has been rejected or allowed. Anyway, in any case, also direct I can take instruction.
Notice on the question of admission indicating therein that matter shall be disposed of by the state of Land Council for the state, accept notice on behalf of the opposite parties. Extra copies once on be served. Matter to be listed on 24th June 2020.
No, now they have issued a demand notice under Annexure 13.
Application accept issue notice for them.
Lordship, take, because otherwise they will go for settlement and they will encase the bank guarantee. They have stated in the
come on 24/6/2020.
Till then, no coercive action.
Is next 13.
Not other 2 matters are similar. Connected 2 matters. No, but other 2 cases, in the so cause notice, I have submitted reply. In this first case, I have not submitted reply. But with relaxation of 10%, we have given.
Okay, all these matters will come on 24. Yes. On IA also notice. Yes.
Connected matters also you take instruction.
All matters not come.
Yes, next.
Matter the petitioner.
Item 13.
Matter the petitioner challenge the issuance of 13(2) notice on the surface act matter of Annexure 1. The petitioner has taken agricultural loan mallet from the Utkal Gramin Bank, Bhojpur branch, and for a tractor loan for agriculture purpose. Matter and 4,92,000 has been given to him for purchase of tractor. Accordingly, a tractor has been purchased. Matter.
So who is appearing for Utkal Gramino Bank?
Yes, ma'am. Your lordship kind of
Tuna Sahu. So serve a copy, it will be taken up in the next vacation.
So they are taking possession, madam. They are going to take possession, madam, and
that we do not know. This matter, as for the settled law, this surface eye matter is not. You have to approve the other authority.
Madam.
But before going to that, we just want to hear the Land and Council who usually appears for. So serve a copy.
I am ready to
We are
pay, madam.
reflecting.
Why they
Have you served a copy on Mr. Tuna Sahu? दे दी चंदी
मैं खोजली पाऊनी है सर घर के बोलती
नंबर नहीं जानते मिस्टर राउत लेखो in this writ petition prayer has been made by the petitioner Vaishnav Mahakul for a direction to the bank for one-time settlement. After deducting the subsidy, since it's an agricultural loan scheme of the government. It is stated at the bar that Mr. Tuna Sahu usually appears for Utkal Gramin Bank. Let a copy of the writ petition be served on Mr. Sahu and matter be listed in the next vacation bench indicating the name of Mr. Sahu in the cause list. Give the copy.
Then no cross action, madam.
Sorry, yes, give the copy.
Item 14.
May I please your lordship? My lord, the petitioner availed term loan to the tune of rupees 1 lakh in the year 2007, and the matter was declared NPA on 19/12/2013, 14/10/2011. Thereafter issued notice under section 13.2 and thereafter 13.4, and thereafter put the matter into auction. Your lordship kindly have a glance to page number 1. They stated that
you have submitted a representation on 17/4/5/24.
Yes, my lord, because they charged me the interest and the compound interest.
So what is your instruction?
So I am ready and willing.
Property has been sold and certificate has been issued. Property has been sold for rupees 19 lakh something and on 8/4/2024.
So you have come too early, Land Council. Property has already been disposed of.
Certificate has been sale certificate has been issued.
Sale certificate.
And subsequently, on receipt of the bidding amount, the sale that has been registered.
मैं छुट्टी भीतर dismissal करिया चाहूँ ताकि छुट्टी पड़.
Your lordship kindly have a glance. They stated that he got the certificate.
You want that order? The property has already been disposed of, sold, sale certificate issued. Everything is over. Now you are coming to challenge a notice. So what can be auction notice or come? Sorry.
When they put the matter into auction, that was failed, and thereafter I made the representation on 17/5, praying therein that I am ready and willing.
You have an alternative forum. Now we are in a writ petition, which is not to be entertained. First of all, then all these things. We are.
I have no other land except this land. I am ready and pay the entire amount.
से जो लोग को प्रथम कथा तो जो लोग को ना रे सेल सर्टिफिकेट इश्यू ही ताको पक्ष करना है
सेटा है नहीं सर हम
सुनिले तो वर्तमान
से वर्तमान
तापर जहाँ
in which paragraph you have stated that this sale that process is yet to attain finality?
I have stated that under 3 that auction was not successful, and thereafter I ventilated my grievance.
Mr. Council, you have just now heard the submission of the Land and Council from the bank. So thereafter, what steps are to be taken if you want that you can give some more amount than that person?
Yes, so I'm ready and willing to pay more amount.
It's all right unless that person is now implicit. Sabu katha kon kahibaku padibo na kon. Unless that person, the successful man, is added as an opposite party, how relief can be sought for? How relief can be granted to you? We are just adjourning the matter. Do the needful. Allah. The Learning
May I
Council.
pray one more prayer, my lord? I may permitted to withdraw the matter and will file the better writ petition.
The
my
Learning
lord.
Council for the petitioner seeks permission to withdraw the application to file a better one. Disposed of as withdrawn. Yes, next.
My name is given.
My lord, I am in virtual mode. I am for Director Medical Education and Training in this case. In item number 15.
No, no,
Item 15.
We are in 14 and Council.
We are for open number 4 in 15 and 16.
Yes.
My lord, in this case, the similar cases were before my lord on 28th, and the matter has been posted to 4th of June.
15.
Yes,
Similar.
it is placed to 4th.
Yes, my lord. Similar matters.
So, can you give the number, one of the number?
WPC 13581 of 2020.
Just a minute. WPC
13581 of 2020.
2024.
Yes, my lord. On 28th, it was there as item number 9.
All right. You are appearing for whom?
I am appearing for DMT here in this case for 1, 3, and 5.
1, 3, and 5.
RC Mahanti.
We are for open number 4.
The
Indian Nursing Council, yes.
Appearing for opposite party number 1, 3, and 4.
5.
1, 3, and 5. Submits that similar writ petition by WPC number 13581 of 2024 has been posted to 4th of June 2024. Put up this matter along with Swansea on the next vacation bench, that is on 4th June 2024.
15 and 16 same.
Item 16 also same.
16 also same.
My lord, we are appearing for open number 4, my lord. Indian Nursing.
You have filed your VNAMA?
My lord, we will file our appearance.
By appearance, we are filing. Already we are filing appearance.
It is stated by the Learning Council, Swansea. Please give the name. That
Already you are given the slip, my lord. Already you are.
Acha.
Already somebody slip.
Filing for Swansea slip given, sir. Name be reflected in the cause list. WPC number 13581 of 2024 to be listed on 4th June 2024, along with this item number 16 also. Yes, next.
Great. Item 17.
So here, my lord, the petitioner has challenged the notice of auction sale. But in the meantime, my lord, the matter has been settled between the parties, and the settlement letter also issued by the finance company.
You want to withdraw this?
I may be permitted to withdraw. I am filing the settlement letter with the memo.
The Land Council for the petitioner submitted that matter has been amicably settled between the parties. He has produced the document to that effect and seeks permission to withdraw the writ petition. Accordingly, the writ petition is disposed of as withdrawn. Yes.
Obliged.
Item 18.
The petitioner's grievance before my lords is very short and limited one. In fact, what I am proposing is government should support this stand. The reason being, it is in the interest of the state's revenue. Lordship sees, I was issued with the license being selected in the lottery. In the last lottery, I was selected, I issued with the license. I'll just show my lords one page, one just page. That is page 97. 96. One just page, my lord, let's see page 96. Roman 8. The exclusive privilege once granted shall continue for a period of 5 years, including the year of grant, unless otherwise directed by the state government. The exclusive privilege holders shall renew the license on terms and conditions generally prescribed by the state government from the year to year till completion of 5 years. Meaning thereby, this exclusive privilege is for a period of 5 years, annual renewal. Every year, the license will be renewed, and on payment of the duty, license fee and MGQ, he will be allowed to operate for that year. These are all on advance payment. Similarly, they have also given one more order, that is page 103 month. Annexure 7. Penultimate paragraph. Further.
90?
Not page 103.
103. Yes.
Correct.
Yes.
Further, the exclusive privilege once granted shall continue for a period of 5 years, including the year, unless the same thing which I placed. Now, what has happened? Admittedly, the petitioner became defaulter in the last excise year regarding lifting of MDK. That's an admitted position. Now, after becoming a defaulter, Lord, they challenge that, as in the other cases, Lord, they challenge that they have become unsuccessful. That is the admitted position. Now, today, the government in its wisdom has given a benefit to the licensees that you, so far as this default dues are concerned, you pay, if you pay all these dues in 3 installments, then that will be regularized and the government will realize the demand. That your lordship will see page 13.
30?
Page 13, my lord, 1-3. Page 1-3, annexure 1.
Yes.
Kindly see, my lord, in inviting a reference to your letter dated 3/5/24 on the subject cited above, I am directed to say that government, after careful consideration, have been pleased to accord approval on alternative 1 of your proposal, and the exclusive privilege holder licensees shall be allowed to deposit the deficit amount along with 10% fine on installment basis. 50% of the amount of the first installment shall be by 25th of May, 30% by second installment by 15th of June, 20% third installment by 15th of July 24. Now they in their own wisdom, they have given this benefit of depositing the defaulting amount in 3 installments. Admittedly, my lord, the first installment I have been defaulted because I am approaching your lordship for the reasons. Now, having given this, if your lordship sees,
No, have you deposited?
No, lord, I am before your lordship only for the limited purpose that the demand is 78 lakhs. Give me certain more installments, I'll pay it, and I'll run my shop. I'll pay the dues. I'll exercise the exclusive privilege in the state's interest.
So, no, 50% means kete asuchi bartana.
Sir, demand ta hochi tike dekhuntu page 14 re. 78 lakhs 20,000. Installment mate
39 lakhs. Around 39 lakhs.
Sir, mate installment ti relax kar dele. I'll pay it. I'll honor the demand.
Apono 39 lakhs ru bartan kete dei paribe kontu tangu se instruction debe. Kete dei paribe apono.
My exclusive privilege, as I have shown to my lords, that is till completion of 5 years. Well, I don't want till 5 years. I only say
that period is already over, but you are ready and willing to pay that first installment.
15th of July samane last installment rakchanti. But if I pay the whole dues by March 25th to 2025, entire amount I'll pay by March 2020.
March
2025. The coming year excise year, before end of coming year excise year, I'll pay the entire dues in installments.
Why don't you file an affidavit to that?
I'll file affidavit, man.
File it.
I'll file affidavit.
So that that can be done. Because
my lords may record my submission, but because every day counts for me.
Yes, Mr.
My lord is saying
something. That he can take in.
I'll take it.
Okay. This writ petition has been filed by Ashwini Kumar Jena with a prayer to quash the letter dated 17/5/2024 issued by the opposite party under Annexure 1 and demand notice dated 21/5/2024 to the extent of deposit of excise duty in 3 installments, that is by 15/7/2024, and for a further direction to the opposite parties to allow the petitioner to deposit the demanded amount under Annexure 2 before expiry of the term of exclusive privilege by 31st March 2026. The learned counsel for the petitioner drew the attention of this court to Annexure 1, where the government has ordered as follows. Quote from this paragraph number so and so. The learned counsel for the petitioner submits that the petitioner has failed to deposit the 50% of the amount as first installment by 25th of May on account of financial difficulty, but the entire demand amount as mentioned under Annexure 2 is to be cleared by March
by 31st of March 2020.
by 31st of March 2025, and he intends to file an affidavit that by how many installment he would clear of the said amount. Put up this matter. ଆପଣ 4 ତାରିଖରେ ରଖିଦଉଛି ଫାଇଲ କରନ୍ତୁ affidavit ଟା।
ସାର୍ 4 ତାରିଖ ମୁଁ ନାହିଁ,
ରହୁନାହାନ୍ତି, କେବେ କହୁନାହାନ୍ତି, ଛୁଟି ପରେ ନା
ମୁଁ ଯିବି ଭାରି, ମୁଁ ଆସିବି 14ରେ ଫେରିବି।
ନାଇଁ, ରିଓପନିଂ ରେ ରଖିବା ନା
7 ତାରିଖ ଆଗରୁ ଯଦି ଗୋଟେ ଡେଟ୍ ହେଇପାରିବ ଭଲ।
ଆଉ ତ ନାହିଁ, ଭ୍ୟାକେସନ କୋର୍ଟ ନେକ୍ସଟ ହଉଛି 4 ତାରିଖ।
ଆମେ ମେରେ ଅଛୁ ନା?
ନାଇଁ ଆଉ ନାହିଁ, ଆଜି ଲାଷ୍ଟ କୋର୍ଟ।
ତେବେ ଆପଣ କେବେ କରିବେ?
ଆପଣ ଆଭେଲେବିଲିଟି
ମୁଁ ଖାଲି 7 ରୁ 14 ନାହିଁ, 7 ରୁ 14 ମୁଁ ନାହିଁ।
ତାହେଲେ 6 ତାରିଖରେ ଗୋଟେ
6 ତାରିଖ।
ଆଚ୍ଛା, list this matter on 6th June 2024. The affidavit shall be filed, each serving a copy on Mr. Janmay Jay Katkal and an additional government.
One more just prayer.
Yeah.
But you let my learned friend also obtain instruction, since matter is coming on 6th, on immediate deposit of 25%, if they will allow to operate the shop, so that every day counts for me.
We do not know that what would be your proposal. So
right.
ଆପଣ ମନେ କରନ୍ତୁ ପୁରା କମେଇ ଦେବେ, they may not accept it. So
correct. No, I'll also be try to reasonable.
So
that can also, you can also indicate in the affidavit
that I can also
deposit 25%.
Yes.
Right. That also indicate. Yes. 6th June 2020. Yeah. नहीं डाकी दियो कुछ ना।
Item 19.
May be Lords. Termination of the contract because of the laches of the opposite party is the subject matter of the writ application. Well, may turn to page 16, my lord. Sorry, 15, my lord. Annexure 1. The left side, my lord, we see lot description. It has been agreed. Annexure 1, my lord. Page 15, my lord. At the top, just below 2-3 lines, my lord. Lot description. So at the time of this bidding, when I was successful, it was agreed between the parties that 319 number of wagon has to be supplied by the opposite party for the purpose of cleaning, my lord. As per the procedure, my lord, earlier the railway authorities, my lord, they used to pay money for the purpose of cleaning. For the first time, they have developed this system, wherein with the agreement that whatever the residue found from the wagon, that will be given to the present persons who will take the responsibility of cleaning the wagons, and by the process, the concerned person has to also pay money to the railway department. And accordingly, when accepting the particular proposal, I submitted my tender paper. It was found successful, and accordingly, the work order has been issued, where it was agreed that at least 319 wagons will be supplied per day for the purpose of cleaning, so that I will use the same type of manual men and other employees for the purpose of cleaning. So no deviation. Then I pray my lord to have a glance to next page. Next annexure 1 or 2 is the work order, but I pray my lord to have a glance to annexure 3. That is clause number 9. In the clause number 9, it has been specified that the annual license fee liable to be paid by the contractor shall be reconciled at the end of each year based on the actual number of wagons offered and cleaned. The license fee already paid stroke to be paid shall be relaxed based on the reconciliation at the end of the year. So, my lord, with this, my lord, I continued my proposal, my lord, work, and I have paid 64 lakhs some odd per quarterly, my lord. So 2.5 crores I have already paid. That is annex number 5, my lord. There is no dispute over it, my lord. Now, before that, as because of the fact that they have supplied only 119, that is about 1/3 of the particular wagon supplied, I approached the authorities by annex 5 to 9, my lord, that you reconcile, because the year is going to be end. So you reconcile the particular process, because by the process, the amount of 64 lakhs, which has been to be paid quarterly, will be reduced to 1/3. And in the meantime, you have taken around 2.5 crores from me, so that if it will reconcile, I will get, I will be in a position to get back of the money, or it will be money which I have paid, it will be adjusted in the quarter, in the next
well, quarterly installment, my lord. By the process, well, they have not responded. Now they have issued, my lord, annex number 11, my lord. Annex number 11 said that as because of the fact that I have not paid the amount of the next, my lord, fifth number of one manual license fee, my will be cancelled, my lord. It has been terminated, my lord.
Which order?
My lord, on page 30, my lord, annex 11, my lord. And also they have said the appeal provision is there. If
the
you want,
contractors fails to pay the full due amount specified even after the expiry of the grace period and so on. So there is an appeal provision here.
They have said so for appeal. And accordingly, I have also prepared the appeal, my lord.
So what relief you want?
My lord, I have also filed the appeal. In the appeal also, I failed, my lord. My lord, may turn to page 13. Order of the appellate authority, my lord.
Yes.
No reason has been assigned.
My lord. And my only my subsequent prayer have a glance to annex number 14. That's page 43. When they have
rejecting your appeal, why annexure?
No,
my lord.
So what do you want now? Is that can we entertain, or there is other forums?
No other forum. No, my lord. After this disposal of the appeal, it is the only forum available before my lord. And only my prayer, my lord, because of all these things, I have paid a substantial amount of 2.5 crores. I have engaged laborer and all this manpower is there, my lord, and they are still waiting, my lord, without any work. And by the process, I am also ready because it is their contract that after 1 year, my lord, that means not, my lord, 1 year, my lord, starts from the date of entrustment till particular period, my lord, 1 year, my lord. And the date, my lord, as I found, my lord, kindly see annex number 2, the work starts from 16 to 2023. My lord, may see annex number 2, page 16, my lord. And
no, is it the order passed by the appellate authority under Annexure 13?
My lord. My lord, see appeal, my lord, may see.
Your appeal so against so was received in all aspects. Computer has decided to regret your appeal, thereby upholding. So who is to appearing, so on?
Yes, we are appearing, ma'am.
What is this consideration?
On examination of the pleadings, first time it was listed, it was said that there is a recorded statutory provision under the 2007 Orissa Minerals Rules 2007. The provision here to give the approval from the authority concerned. It was not given. What government they have taken? That's why Lordship may come to page 4, paragraph 5.
Mr. Padi, we are just on one point that he has.
This appeal was disposed of.
Preferred an appeal, and he has taken. This appeal runs about 7-8 pages, and he has taken some of the grounds A, B, C, D, E, F, G, and you are disposing of this appeal just like this. Your appeal against so and so was received in all aspects. A competent authority has decided to regret your appeal, and thereby. So no reason.
Non-speaking order, yes.
Non-speaking order. That is the reason why.
Lordship may keep it to next sitting. In the meanwhile,
the learning counsel for the Mr. Manas Chan, learning counsel, submits that against the order passed
termination
by the assistant commercial manager, office of the senior divisional commissioner manager,
Mr. Manager, OP number 3,
or not considering the petitioner's representation filed to reconcile the license fee in terms of clause 9 of the contract agreement based on actual number of wagons offered and cleaned, and subsequent final order of termination of contract agreement with immediate effect communicated by later dated 28/3/2024. If preferred an appeal before the appellate authority cum divisional railway manager AC Relay, Chakradharpur, which was registered as, what is that number?
Number they have not mentioned, but they have disposed of by order.
But that was when you preferred that appeal on. Date has been given.
Yes, my lord. Annexure number 12, page 31. They have received
on 24/4/2024, which was received by the authority on
24/25. 24, my lord, it's 25 next day, 25 4
on 25/4/2024. But by Annexure 13, the appeal has been disposed of, holding as follows. Quote from page number Annexure 13, page 42, second subpara. Your appeal by letter under so against termination was received in all respect, and the competent authority has decided to regret your appeal and thereby upholding termination as per extant guidelines, inverted comma with a rel. The Learned Counsel for the petitioner submitted that it is a non-speaking order. The appellate authority has not taken into account the grounds taken in the appeal. Therefore, the order under Annexure 13 is not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. The so Mr. Parties enters appearance for all the opposite parties.
Oh, yes, all the opposite.
All the opposite parties. Extra copy so be served on him. Matter to be listed on 24th, Mr. Party.
24th, man.
24th of June 2024. Yes.
IA is there.
What you are expecting?
My lord, may say, because of the fact that as I have my lord contended that around 2.5 crores they have taken, and if it will, my lord, 119 will be supplied, it will be less than that. So my lord says, subject to payment of some money as my lord fixed, I may be allowed to continue.
Let him take it.
That part I will take instruction.
That is not your prayer. Your prayer is to stay operations for Annexure 11 and 13.
My lord, because of the fact, my lord, I have paid, my lord,
Whatever it may be, you have prayed
my lord,
to stay operational for Annexure 11 and
my lord, that is there.
and you are making
So, sir, issue notice kar diyo. I hear issue notice kar diyo. Yes, next.
no coercive
No coercive action.
no coercive action.
In pursuance to Annexure 13. Till next.
Problem.
Along with Mr. Castro be checked.
And you also filed this condition of contract.
Well,
you have not disclosed the same.
No,
condition of contract.
I filed, my lord, Messi.
Where? No, the 13.2, 19.1 at a kudos.
Annexure number 3, my lord, Messi.
No.
A special condition of contract, my lord, Messi. Annexure number 3, page 17. 17, my lord. I placed also
13.2 kai 16.1 kai nahi eta nuhe eta alga dekho
I'll
okay, next
urgent copy, man.
Item 20.
May it please your lordships. My lords, here in this case, the petitioner is a recognized state political party, my lords. Now, elections for the state of Orissa were declared in 4 phases, my lords, by various notifications on 13/5, on 25, both for parliamentary as well as assembly constituencies, 13/5, 25, 25/5, and 16. These are the polling dates, my lords. On these 4 polling dates, my lords, elections were declared. Now, my lords, your lordship, under section 77, my lords, there is a direction of the under the RP Act that I am to have an expenditure within a permissible limit. I'm taking your lordship. I'm taking your lordships to section 77.
Yes.
Your lordship, account of election expenses and maximum thereof. Every candidate at an election shall either by himself or by his election agent keep a separate and correct account of all expenditure in connection with the election incurred or authorized by him or by his election agent between the date on which he has been nominated and the date of declaration of the result thereof, both dates inclusive. Now, your lordships will kindly turn to subclauses 2 and 3. The explanations will come later on. Subclauses 2 the account shall continue such particulars as may be prescribed. The total of the said expenditure shall not exceed such amount as may be prescribed. There is a clear mandate that I cannot exceed the expenditure as has been prescribed. Now, my lords, there is another concept which is a star campaigner. Who is the leader of the party? It has been given an explanation.
Which explanation?
Explanation 2. Explanation 2 of section 77. Lordship, for the purposes of clause A of explanation 1, the expression leaders of a political party in respect of any election means where such political party is a recognized political party, such person not exceeding 40 in number, and where such political party is other than a recognized political party, such persons not exceeding 20 in number, whose names have been communicated to the Election Commission and the Chief Electoral officers of the state by the political party to be the leaders for the purposes of such election within a period of 7 days from the date of notification. So we recommend these people. They are, my lord, accepted as star campaigners by the election commission. It is the recommendation of the state political party. Now what happens? My lords, whenever a star campaigner attends a meeting, my lords, initially there were instructions at annexure 2, my lords, I'll take your lordships to that annexure, that whenever a star campaigner attends a meeting, the election expenses are to be apportioned 1:1. That is 1 to the kitty of the parliamentary candidate and 1 to the kitty of the assembly candidate. For example, my lords, let us say the expenses are 1 lakh. And let us say, my lords, the star campaigner has attended the meeting or the rally. Then the expense is divided 50,000 to the parliamentary candidate and 50,000 to the assembly candidate. Your lordships may see annexure 2. This is in the handbook of in the compendium of instructions on election expenditure monitoring, which has been issued on January 24th. Lordships may see annexure 2 at running page 35.
Yes.
Lordship gets it at running page 35. In supersession of the Commission's letter of such and such date dated on the subject, I am directed to clarify as under. If any attendant, including security guard, medical attendant, or any person, including any member of the party, who is not a candidate in the constituency concerned, or any representative of the electronic or print media travels with the leader, star campaigner, the leader is the star campaigner, of the political party in his vehicle, aircraft, helicopter, then the travel expenses of such leader shall be wholly booked to the account of political party, provided that the said member of political party or media person or attendant sharing the transport with the leader, star campaigner, do not play any role in election campaign for any candidate in any manner. However, if any such persons sharing the transport with the leader plays any role in election campaign for the candidates in any manner, or if any candidate travels with such leader in his vehicle, aircraft, helicopter, then 50% of the travel expenditure of the leader shall be apportioned to such candidate. The names of leaders of the political party, star campaigners, as defined in explanation 2 of section 77(1) of the RP Act, are to be communicated to the Election Commission of India. Now your lordship turns to paragraph D, which is the main paragraph that I am relying upon. If the rally stroke meeting is organized in the constituency of the leader, star campaigner, where the leader shares the dais with other contesting candidates, then the meeting expenses is to be apportioned to the election expenditure of the leader and all such candidates. However, if he, star campaigner, is taking part in a rally meeting along with other candidates of his party outside his constituency, then the meeting expense shall be apportioned to the election expenditure of all such candidates for whose election campaign such rally meeting is organized, and no part of such rally meeting expense organized outside his constituency shall be added to the election expense of the leader, that is star campaigner. In other words, my lords, for example, if Mr. Naveen Patnaik campaigns outside my lords Barampur constituency, let us say in Cuttack, then the expenses that has been given by way of example by a later notification Then the expenses, if it is at 1 lakh, it will be apportioned equally between the candidates. That is 50%, 50%. If there are
means
three
not only the Lok Sabha, but also the
assembly, also.
assembly.
Exactly.
Okay.
It will be apportioned.
Right.
Now, Malak, these are the instructions which were governing the field when the election started. Now, suddenly on 22, this is dated 22 May 20.
And when these expenses used to be given?
Date of notification, it continues, my lords. After the election is concluded, we give the expenses.
After election is over.
After election is over.
Also kindly see section 78. After 78, my lord.
70.
After election is over, my lord, within 30 days, they have to submit the expenses to the district election officer.
Exactly.
The district election officer will notify for the public and he will make his note, then he will communicate to the Election Commission of India. Your Lordship, kindly see section 78. 78. Every contesting candidate at an election shall, within 30 days from the date of election of the written candidate, or if there are more than one written candidate at the election and the dates of their election are different, the later of those two dates lodged with the district election officer an account of his election expenses, which shall be a true copy of the account kept by him or by his election agent under section 77.
Malaks, that will be communicated out. That's what I'm saying. The elections, as I've placed 77, the counting of election expenses will start from the date of his nomination, and my lords will end up on the date of, if he is returned, on the date of his return. And then I'll have to submit the accounts within 30 days to the DO. Now, suddenly, my lords, the impugned annexure 4, at page 42.
Yes.
My lords, by the impugned annexure on 22nd May 24, this letter has been communicated to us on the 24th. That is one day before the third phase election. They have, in Orissa, my lords, they have superseded that previous instruction. Your lordships may see, kindly see, in supersession, lordship gets page 42.
Yes,
in supersession of the instruction contained in para D, that is what I was showing before your lordship, of the commission's letter number such and such regarding sharing of expenditure in a meeting rally contesting candidates present on dais with star campaigner, I am directed to state that the commission has revisited it and has directed that sharing of expenditure shall be done as under. When more than one contesting candidate of both AC is assembly candidate, and PC are present, that is PC is parliamentary candidate, in a rally meeting, and share dais together with sharing of expenditure shall be in the ratio of 3:1.
Okay, it was changed in the midst of the
election, and they have made it applicable to the ongoing Lok Sabha election 24. That is the last page 43, para 3, my lords. Lordship says this is what is actually hurting us. The above instruction of the commission shall be brought to the notice of all DEOs, ROs, expenditure observers, concerned election authorities, contesting candidates, star campaigners, and political parties for their guidance in ongoing Lok Sabha election 24 and state legislative assembly elections of Andhra Pradesh,
your
Odisha.
apprehension is that if in that process this expenditure this account of expenses the limit that may likely
that will be broken, because my lords, if it becomes, initially it was 50-50. I have arranged my finances keeping that 95%, 95 lakhs barrier in view, my lords. Now, my lords, if it becomes 75, and mostly your lordships are aware, in all regional parties, star campaigners are present in every meeting, my lords. So, my lords, my barrier will break. Mostly the parliamentary candidates will suffer. My lords, the barrier will break, and it will go beyond 95 lakhs. In our representation also, we have given, in our objection also, we have given that this is how we are affected, but there is no response from the side of the
Where is your objection?
Annexure 6.
26/5/2020.
Yes, my lords.
So it is now pending before.
My lord?
It is, any order has been passed on
Nothing,
this?
my lords. And my problem is the date on which the elections are declared. If I exceed the permissible limit, then, my lords, the ECI can disqualify me under section 10A of the RP Act.
So what is your prayer now? What is
My
your
prayer is, my lords, this has to be quashed, and my lords, it is the fag end of the election.
just last.
And they are giving it a retrospective effect. Your lordship is aware that only the parliament has the authority to, my lords, enact retrospective legislation. This they cannot do, my lords. They cannot make it applicable to the ongoing election 24. And we have already booked our expenses and submitted our accounts, keeping this 95 barrier in view, my lords.
Take instruction in this matter.
Here, my lord, my submit is a premature writ. This representation election commission has received on 29th. And on 29th, this writ application has been filed. So within a reasonable time, we will dispose of his
26 we have given.
We have received on 29th.
It's all right. We are keeping just on 24th June. You just take instruction.
Yes,
Whether in the meantime, if it has been
Yes,
disposed of, it's all
And
right.
regarding disqualification, election commission cannot disqualify. Your lordship kindly see rule 88. We have to, once they file a election expenditure with the DO, my lord, then if there is any discrepancy, he is to be heard. A notice to show cause has to be issued before passing disqualification order under section 10. Your lordship, rule 86. Conduct of election rules 1961.
86.
86, my lord. The accounts are to be submitted, then your lordship may turn to rule 87. Notice by district for inspection of accounts. Then your lordship section rule 88. Inspection of account and the obtaining of copies there. Then important is 89. The report by the district election officer as to the lodging of the account of election expenses and the decision of the election commission thereon. As soon as may be after the expiration of time specified in section 78, for the lodging of the accounts of election expenses at any election, the district election officer shall report to the election commission so and so, so and so. Now, your lordship may turn to sub-rule 5. Where the election commission decides that a contesting candidate had failed to lodge his account of election expenses within the time and in the manner required by the Act and these rules itself by notice in writing. So there is.
All right. This
I have given my appearance here.
Mr. Milan Kanungo, Senior Advocate, files appearance memo, which is taken on record. Mr. Gopal Kumar Agarwal, Land Council, files appearance memo for the opposite parties, which is also taken on record. The name of the Land Council be reflected in the cause list henceforth. This writ petition has been filed by petitioner Biju Janata Dal through its General Secretary, Dr. Shashmit Patro, challenging the later oblique instruction dated 22/5/2024 under Annexure 4 and consequent later dated 24/5/2024 as under Annexure 5. Mr. Kanungo, Land Counsel for the petitioner, drew the attention of this court to section 77 and 78 of the Representation of People Act. Section 77 of the 1951 Act deals with account of the election expenses and maximum thereof. And 78 deals with lodging of the account with the district election officer. The Land Council for the petitioner submits that by issuing Annexure 4 and Annexure 5, the authorities have changed the what they have changed according to
calculation of expenditure.
the calculation of expenses we in the midst of election, in the midst of assembly
Calculation ratio.
Calculation ratio, in the midst of the parliamentary as well as the assembly election, which is not permissible in the eye of law. It is further submitted that after receiving annexure 4 and 5, the petitioner has submitted his objection to the Chief Election Commissioner bracket Chief Election Commissioner has not been made that is Chief Election Commissioner opposite party number 1, which is dated 26/5/2024, but no reply has been received from the opposite party number 1. Mr. Gopal Agrawal and counsel submits, appearing for Swanso, submits that the matter may be placed after ensuing summer, in the week commencing from 24th of June 2024, and the result of the consideration of the objection filed by the writ petitioner, if taken in the meantime, will be apprised to the court on the next date. In view of such submission, court of this matter on 24th of June 22. You are also appearing for opposite party number 2, who is also appearing for opposite party number 2 and 3.
Well, I pray for stay of the, otherwise
But
your lordship may issue notice.
I hear a issue notice.
No coercive action against anyone.
No, they have not. There is no scope for yes, next. Yes.
Item 21.
This case also is
Yes.
Obliged.
May it please, my lords. Lordship, pardon me, my lords, I am appearing virtually. My lords, in this case, the petitioner challenges, my lords, Annexure 7, the demand notice issued under Annexure 7. The facts are like this, my lords. On, my lords, a show cause was issued. Your lordship will find that in page 20, 33, show cause 32. I'm sorry, my lords, page 29. Page 29, the show cause. Start from 28. You are therefore requested to submit, last paragraph, my lords.
Yeah.
You are therefore requested to submit your show cause reply to this office by 10/4/2024 positively in the following points, failing which it will be presumed that you have nothing to say in this regard, and action shall be taken against you without any further notice in accordance with law. As to why the demand notice of shortfall of MGQ shall not be issued against you for such huge loss of government revenue towards the MGQ duty. Why the said amount shall not be adjusted from the bank guarantee fixed deposit submitted by you. Why the shops shall not be put to fresh settlement. Why you shall not be declared as a defaulter under Rule 149. I would take a pause here, my lords. 149 rule mandates uses the expression.
Just a minute.
Mine.
Yes, Mr. Palis, please continue.
Grateful, lords. Rule 149 prescribes uses the expression willful default. I just take, my lords, 1 second to place that part, my lords.
After receiving this show cause notice, what you have done, Mr.
I have given a reply. Your
What is that reply?
Extensive reply I have given. Page
Annexure 6 is the reply.
Annexure 6 starts from page 31, 32 and 33 spread over.
What happened thereafter?
And manage the disposal, page 34, without addressing any of the issues in the show cause. The main issue in the show cause has not been addressed. Page 34, first paragraph. There is no provision. Cryptic disposal. It's virtually a non-speaking order.
Hey, who is appearing? You are appearing for
something like a type. No, he's assisting man. Is my briefing.
Okay, then who is to be? Who is there in the state of Orissa? Oh, what sort of this disposal is? It's strange that Just the so-called reply
The
submitted by
application
you
mine-
is not in, has been examined in consonance with the so and so. So just rejected. No.
No reasoning, nothing. my
All
lord.
right. Yeah. Hard, Mr. With
Your Lordship has just quashed a set of show causes like that.
let him obtain instruction.
My
We are
lord.
taking up this matter.
My lord. Grateful.
The London Council, the petitioner Santilata Kuntia has filed this writ petition challenging the demand
Give me
notice
notice
dated
9/5/20.
देखिए लिखिए prayer को, है ना?
9/5/20.
Council for the London Senior Advocate submits that after receipt of the so-called notice under Annexure 5, the petitioner submitted a detailed reply under Annexure 6, but by the cryptic order, the it was the reply was rejected on the ground that there is no merit for consideration, and the petitioner was directed to deposit the amount as per Annexure 7, which is clearly illegal and not sustainable in the eye of law. The Land Council issue notice on the question of admission, indicating that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice for all the opposite parties. Let extra copies be served on so and so. Put up this matter on 24th of June 2024. IA number so and so. Issue notice, one exception, one set of process visual. No coercive action shall be taken till next date.
Grateful, my lords. Deeply obliged.
Item 22.
To it is a securitization matter, madam. I have come before the challenging Annexure 7, that 13.2 notice. 13.2 notice under section under the Reproduction Act, madam. I have served the copy on my friend, madam, who appears for the bank, madam.
No. When that 13.2 notice was issued?
27/3/24.
So thereafter,
Annexure
have you submitted your representation?
Representation, that is Annexure 8 under section
Yes,
13.
that is dated 22/4/2024.
Yes, one within that time, because
it's all right. So what reply you have received?
No, not yet.
What is the, have you obtained instruction whether it has been considered or not?
This representation has not been considered and has not been disposed of.
Yeah.
So prior to that, he has submitted an OTS proposal, and that OTS proposal has been rejected. Lordship kindly see Annexure
madam.
6, my lord. Annexure 6 at page 50.
No, after this 13.2 notice,
Yes, my lord.
see just Annexure 7. In the 13.2 notice, you are specifically mentioning that the bank calls upon you notice to discharge so and so. So after receiving the 13.2 notice, he has a right to submit the representation.
Yes.
So that is how he has submitted.
Yes.
So if you are not disposing of the annexure, you just pray that representation be disposed of. That is his prayer only.
Lordship direct, my lord.
All right. The
And my lord, one thing.
Within a stipulated time,
Yes,
you dispose of
yes.
the and the result thereof be communicated
Yes.
to the. The writ petition has been filed by petitioner Mrs. Ranjit Fly as Briggs, challenging the notice under Annexure 7 issued by the opposite parties under Section 13(2) of the SurfaceI Act, wherein it is mentioned that the outstanding liability due owing to the bank is so and so, and it dekhi likhiyo and interest so and so. The Land Council for the petitioner submitted that after receiving such notice, the petitioner submitted a representation under Annexure 8 on dated 22/4/2024. He has submitted the receipt in proof of submission of the representation. It is the further submission that the representation is still pending with the authorities. ଆପଣ ଫାଇଲ ପାୱାର କଲେ ନା କଣ କେମିତି?
I have instruction.
ଆଚ୍ଛା, so and so has instruction. ଆପଣ ନା ଇଏଟା ଦେଇ ଦିଅନ୍ତୁ to enter appearance of so and so, and his on instruction submitted that the representation under annexure 8 has not yet been disposed of. Taking into account the limited prayer made in this writ petition, we dispose of the writ petition with direction to the opposite party to consider the representation in accordance with law and dispose of the same, and result thereof be communicated to the petitioner within 2 weeks from the date of consideration of the representation, to taking up the final decision on the representation. It is made clear that we have not expressed any opinion on the merits of the representation. Accordingly, writ petition is disposed of.
Item 23.
Yes.
Taking instruction, my lord, the minor girl of the minor daughter of the petitioner, June kidnapped by
process is going on. By number of the CDR data has been analyzed, but her mobile phone has been switched off, and also spies have been deployed to find the victim.
Whatever you have done in the meantime,
yes,
just file an affidavit by that IO that what you have done. We also wanted you to produce the case diary. So, whatever you have done, just file an affidavit. We are adjourning this case. The Learned Counsel for the state, Mr. Learned Additional Government, submits that he has received the case diary, which shows that the investigation is going on, but the victim has not yet been traced, and all efforts are being carried out by the investigating agency to trace out the victim. And you will file an affidavit regarding the progress of investigation by the next date. Put up this matter in the week commencing from 24th June 2024. Yes.
Item 24.
The victim has been rescued by instruction.
Your Lordship, in this matter, I am appearing for the petitioner. Lordship, in this matter, the minor daughter of the petitioner has been kidnapped and wrongfully restrained by the opposite party number 4, with connivance with the opposite party number 5 and 6. Lordship, we have filed the FIR. However,
are you not hearing what the submission, the Land and State Council submits, that the victim has already been rescued? What is your instruction?
Your Lordship, I have no instruction regarding that. I'll talk to you.
So it would just be disposed of.
Your
It has been handed over to the. What is your instruction?
Plus, yesterday in the night, I've got the information.
No, any
Accused has been arrested
on
from
the
us.
phone. Just file that. Just it will
He's a
be.
child in conflict with law. The accused.
नहीं वर्तमान थी रेस्क्यूइंग इन कोर्ट ही अच्छी
पापा पाके बच्चों ने कवर चाहिए.
just would writing in writing produce କରନ୍ତୁ so that it can be closed.
I have not received any written instruction.
ସେଇଥିପାଇଁ ଆପଣ ଦାମ କହୁଛି ନା ଆପଣ ତେଣୁ ବର୍ତ୍ତମାନ ଆପଣ ଯଦି ଗୋଟେ କଣ in writing ଦେଇଥାନ୍ତେ we could have closed
Yes,
this.
yes.
All right. This WPCRL has been filed for so and so. Land and Additional Government Advocate Mr. Katki has submitted that he has received instruction over phone that victim has been rescued, but he wants to file written instruction to that effect, showing that in whose custody the victim has been handed over. Put up this matter in the let it come on 4th, then you just put up this matter in the next vacation bench that is to held on 4th of June 2020.
Also, petitioner should take instruction.
Also, the Learned Counsel for the petitioner also offered instruction in that respect.
Yeah. Item 25.
My lord, the state has preferred this writ appeal against the order judgment dated 17/1/24.
There is some delay, Mr.
My lord, 94 days.
So let notice go.
My lord.
IN number so and so. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 95 days in filing this writ appeal. Issue notice. So who are the opposite parties here?
Well, the opposite party is the writ petitioner only. Respond.
So, why don't you do one thing? You send a copy of this writ appeal to the IIC of that Balikuda police station so that it can be served in order to curtail the delay.
Yes, sir.
Right?
Well,
The copy of the writ appeal be sent to the inspector in charge of Balikuda police station for its service on the sole respondent, and it will be intimated to her that the matter is likely to be taken up on 24th of June 2024, and she is at liberty to file objection, if any, to the delay condonation application put of this matter on 24th June for consideration of the IA. Yes.
One correction, my lord. My lord directed copy of the writ appeal. I will serve the copy of the IA. If my lord directs, I will
No, you serve the writ
Well,
appeal, also the IA.
Well,
Writ appeal will be IA. Puni astiva se kotheba murid. So better you
I will serve the entire writ appeal.
Item 26. Please, my lords. I am appearing in VC, my lords, in this case. There is the tender for it was a pilot basis tender issued, my lords, under the agencies of the Department of Agriculture, my lords. The implementing agency was the Orissa Agro Industries Corporation, my lords. Now, a meeting was held on.
Why it has come, Mr.
It has come, my lords. It has come because of the IA 6933.
6933.
Notice was issued, counter affidavit has been filed by the Agro Industries Corporation, my lords. In the meantime, your lordship issued notice on 2nd of, my lords, 2nd of April. The notice was.
What do you want in the IA?
I want, my lords, they have already stayed, my lords, kept in abeyance the execution of the tender.
To execute the supply order and keep the same in advance. That is your prayer.
That has been kept up in abeyance up to 5th. And I'm only wanting that I may be given a fair opportunity on the reopening day. Let it be taken up on the reopening day. Till then, let them not execute. That's all. Only I'm
number 1 may
for a margin of.
Order number 1 may kindly be seen.
Order number 1.
Yes, sir. While the matter was admitted by the Honorable Court,
yes,
my lord and friend had prayed for stay of the my lord tender. In the meantime, my lord, that time also we had awarded the tender in favor of opposite part number 3, my lord. Now we have come up with a notification which is there in annexure 5, that page 6 of that interim application, that till the model code of conduct is being lifted, this notification is kept in abeyance. Now my lord and friend has filed this interim application stating therein that not to execute the supply order and to keep the same in abeyance.
Yes.
Which is already there. He says.
So there is, you have to say there is no urgency at all.
There is no urgency at all.
Time span is 20 days.
He said,
Mr. Palit also wants that the matter to be twisted after vacation.
Yes,
on 24th, till then, my lords, on 20th, reopening day, till then let them stay their hands. That's all. This public money, my lords, 95 lakhs, almost a crore of rupees. And they predated the tender.
All right, Mr. Palit. IA number 6933 of 2024. This is an interim application filed by the writ petitioner with a prayer to direct the opposite party not to execute the supply order and keep the same in abeyance. The Land Council for the state submitted that. What is your submission?
I'm appearing for the opposite party. I'm appearing for the corporation, my lord. Since the last date.
The Land Council for the state appearing for opposite party number 3. Just see. Odisha Agro Industries. Right. Opposite. So
number 2 and 3.
No, 2 and 3. Right.
2 and 3.
3 submits that at present there is no urgency and in the matter, and recently the no action is likely to be taken. Okay. In view of the submission against no action is likely to be taken against the interest of the writ petitioner.
Till 5th.
So submission of this matter on 24th June.
Annexure 5 only says till 4th. Till 4th. Your Lordship may kindly, for a second, peruse annexure.
Parithikov just heard the submission which was made that they are not likely to take any action against you till the next date we are fixing. So that
grateful, my lord, that be recorded, my lord. That be recorded.
All right.
My lord, a counter has been filed by state government. My lord, I am appealing for opinion for maybe served out on us, my lord.
We'll serve a copy of the counter.
All right. It is stated by the Land and Council for the opposite party numbers 1, so 2 and 3. That
4,
the
my
counter.
lord. 4, my lord.
4, 5 and 6.
No, you are for the
Opinion number 4.
No, like
4.
just listen to that. Opposite party number 2 and 3. Then the counter affidavit file is to already filed is to be served on the opposite party number 4 and 5. In
5,
the meantime,
6, 4, 5, 6.
4, 5, 6. 4, 5, and 6. Upon counter
I'll answer
by the next date. Yeah, Mr. Palit, you have received the counter affidavit.
My lord, I have received. I'll seek permission to file a rejoinder to respond to that.
Mr. Pali submits that he has already received the counter affidavit and he intends to file rejoinder, right? Or you have filed your rejoinder?
No, I intend to file my rejoinder prior to that date, well in advance.
That's all. I'm coming at 3:30 for the single bench.
Obligation.